Hey guys, I'm so sorry I overslept. I don't know why Travis didn't wake me up because he usually does and he didn't. And then Judy texted me I need my phone. I must have been sleeping hard. Apparently, okay, this is what I do. I set Alexa to alarm at 6 a.m. and then I just yell, Alexa, snooze for an hour. And then I get up at 7. That did not happen today. Apparently, when I said, Alexa, cancel at 7, I went back to sleep. And sometimes I will be half asleep and will say cancel instead of snooze. And if I do that, then I usually say, shoot, I meant to say snooze. And then Travis will wake me up at 7. But he didn't do that today because I didn't say shoot. I just said cancel. So he thought I was sleeping in for some reason and he didn't wake me up. So he woke me up to tell me bye. And I was like, what time is it? I gotta get up. He goes, oh, I just thought you weren't getting up this morning for some reason. So I was sleeping good. I was having the weirdest dream though. I watched a Goosebumps TV show the other night. I binge watched the whole season. And there was this actor in it that I like that I hadn't seen in anything in a really long time. And he was in my dream last night. Or I guess I should say this morning. And in my dream, he was a doctor, but he wasn't like an autonomous doctor yet. He was still learning to be a doctor. And I was still learning to be a nurse, but we didn't work together. He was my stepdaughters, and it was my birthday. And my stepdaughters had come over to give me a birthday present, and it was a Mickey Mouse coloring book. So they invited the doctor guy in to my house whenever they were giving me my birthday present. And this actor, I don't know his name. He's some Indian guy, like not Indian as in the country Indian, but American, like second generation, I guess. I don't know. Anyway, Affairs too. So he played in Covert Affairs and also in that Goosebump TV show. I'm purposely not looking at chat right now because Wiggles is trying to distract me. I know she is. So he's sitting there and he's talking to us, and I'm opening up my birthday present, and he says to me, can I tell you something? And I'm like, sure. And he goes, eyes aren't too like Mickey Mouse. I'm like, so what? My husband mouse. Totally stupid, pointless dream, but that's what I'm doing. That's why I'm here. I'm here. A stupid dream. And so then after he left, then the big brag to Travis was, he's not even a real doctor. Like, it's stupid. It was a dream. But I would have much rather been here. Again, this is the week of giving, I guess. If StreamYard will do what I want and put it on the screen, 15 gifted memberships. Don't on the screen. Thank you so much. Yeah, it's telling me. Please don't crash. After her divorce from Broderick, Betty sought a hefty 30,000 per month in alimony. Dan claimed she was only entitled to 7.3 thousand. 30,000 a month? That was an annual salary back then. Do I make that money? Jeez. This difference highlighted their financial disputes, which continued long after their divorce was finalized. Woman, jeez. I won't say she brought the cheating and the divorce on herself, although she may have. But all the other crap, she absolutely did. Well, StreamYard's just going to be sluggish today. Good morning, Judy, Nancy, and now my chat disappeared. Marty. We like it when you're here, Marty. You don't have to be here if you don't want to be here. Like it when you're here. You like it when you mess people. That means you like us. I keep thinking you're talking about Black Betty, but I don't think that's what you're talking about. Oh, Marty, I'm so sorry. Yeah, I have a feeling I have a dog that's about to go to Rainbow Bridge. Betty's being bad. I remember Sawyer Brown. Oh, wow. I'm going to have to look up. I don't know. I thought I was tired last week and then I got a lot of rest over the weekend, so I thought I was good. 940,575. Wow. Yeah, that's true, Marty. It will. And you know, the funny thing is, they used to prescribe bed rest for your back when you had a bad back. Because my boss used to get so mad at me because I would go to her and I'd be like, I'm on bed rest again for a week. It'd be like every 6 months or so, my doctor would put me on bed rest again. And now they say you need to get up and move and walk and because if I'm in the bed too much, my back will actually hurt worse. Like on the weekend, if I sleep in too long, I'll walk hunched over for at least a good half hour when I get up, because I've laid in the bed too long. I can't straighten up all the way. Okay, so Wiggles asked me yesterday if we were done with closing, and I said yes, because I forgot about rebuttal. So we have rebuttal, which 2 hours. Why do you need to do a rebuttal for 2 hours? So we have rebuttal, and then we have the verdict, and then we have her sentencing. And then, although I don't have it ready, so we're going to take a break, then we can start Brooks. Now, there is one trial going on right now, but I don't want to do it. It started, I think it started yesterday, and I didn't notice it until last night. But, you guys, I don't want to do it. If you guys really, really want to watch it, I'll do it. But I don't want to do it. This crazy woman, and you can tell by her picture, she's cray-cray. She stabbed a toddler in a store. She just walked in a store with a knife and stabbed a toddler. And after the last two we did, I don't want to do it. Because the last one we did, the baby in the river, I cried during closing arguments. And I've never, ever done that before. And I think I need... I don't have a problem doing one with kids. But I think I need a break. After the last two with the babies, I need a break. And just looking at this woman's face, that was weird. Did you see that? It was like the light quality changed all of a sudden. My face went from black to red. That's weird. And nothing, I didn't do anything. Like, nothing. But anyway. Yeah, my mom was 29 for a really long time, too. So, yeah, I don't want to do it. And I feel like, I could be wrong, but I think I remember watching body cam footage of this woman. I don't know if it was when she did that or something else, but she looks familiar. I think I have seen body cam footage of this woman. I think there's some mental illness going on with this woman. I wish I could pull a picture, Roy. It's just crazy. You can tell by looking at her. I don't know if they're going. I mean, seriously, it's terrifying, and I don't want to watch it. I don't want to watch it. So we're gonna watch this. Another crazy lady, and then a crazy man. Yeah, see, that one had kids in it. It's not that I'm opposed to doing the ones with kids. I just need a break from the ones with kids right now.
Mrs. Broderick is present. You may proceed, Ms. Wells.
Good morning. I want to start off with making a point, a very important point, I think. You know what and in particular, first-degree murder. You know what the defendant's position is now, which is apparently that she's only guilty or should only be found guilty of voluntary manslaughter. We obviously can't agree. That's why we're having this trial, and that's why we need you. We need you to resolve this case. You're the only ones that can do it. And what you need to know is if you work together and if you conscientiously examine the facts of what occurred on the morning of November the 5th, and you conscientiously apply what you decide, it's going to be the right decision. We are giving this case to you to make the call. It's your call, nobody else's call. And if you do it according to the law, then justice has been served. The people have received it, the defendants received it, and the communities received it. Just make the call. Defense counsel has done a lot of time about emotional issues, starting off with his opening statement with ripping pictures and smashing glass. His argument is designed to make you feel emotionally about this case. It is okay for you to have an emotional response to this case. You would not be human if you didn't. This case is tragic in all sorts of ways. You may even find that you disagree with each other, maybe even passionately, about how you feel emotionally about this case. But the fact of the matter is that no matter how you feel about the case, your feelings are not what should decide the issues here. I don't think you should ignore your feelings. I think you should talk about them. I think you ought to get them out, acknowledge them, and then you're done feeling. It's time to start thinking, because that's why you're here. It's time to start thinking, for example, about the defendant's credibility. The only thing to dispute the cold, hard facts of what happened in that bedroom that morning is Elisabeth Broderick's testimony. And when that's the case, you have to look very, very closely at her credibility. You've got to look at things like, for example, motive. Does she have a motive to be less than candid? And ladies and gentlemen, she has the hugest motive there is to lie, to distort. She has, in fact, killed 2 people. Counsel argued yesterday that if she was going to lie, why didn't she come up with a better story? Well, there's evidence. That room wasn't torn apart. There weren't weapons in the room. But the other reason is, and this is the main reason, she didn't think she was going to need to come up with a better story originally. She thinks she's justified in what she did. She thinks everybody who hears this story are going to agree that she's just. The next day when she was telling him about what happened, she was trying to convince him she was justified in what she did. When she talked to Kim a couple of days later from the jail, she said, "Don't worry, I'm going to be out in a couple of days." When she made the statements to Sylvia Cavins, when a jury hears this story, they're going to let me off. It wasn't until she realized that maybe that wasn't so that she started realizing that maybe she had to come up with something else.
Yeah, but Leah had better hair. You gotta admit.
A little bit better to excuse her act of shooting them in the bedroom that morning. Defense counsel tried to explain last time. He said she wasn't asked a lot of questions about that. Well, she sure was asked the important questions. She was asked directly, "Why did you shoot?" And her response was, "Because Linda moved." That was it. Linda moved, I moved, and it was over. If her attorney had only asked her a few questions about that, that was obviously his choice. We can presume he'd talked to his client and he knew what her story was before she testified. And he didn't ask any follow-up questions like, "Did you hear anything in the room?" All he asked was, "What happened next?" To be less than candid, you have to think about the reaction you had when you listened to her testify. A big part of judging credibility is just your gut reaction of listening to somebody. Although actually, that's probably the least reliable way to judge credibility. All of us have been fooled in the past by people. All of us have been lied to and not known it. People can be good at lying, especially when they've had time to think about their story and to perfect their story. When you think about how she testified, and she was on the stand for several days. You might want to think about some of the differences between how she testified during direct examination, when her attorney was asking her questions, when she was telling her story the way she wanted, with the details she wanted, in the order that she wanted, following her agenda, and the difference between that and cross-examination, when all of a sudden someone is challenging some of the things that she has to say. The difference in her demeanor when someone doesn't automatically accept what she's saying. The evade want to get pinned down on because they didn't support her story. The lack of memory of about things that did her story. Just one of the many examples was when she talked about driving her car through Dan's door. And I'm not even sure if you remember this because there's been so much, but when she was describing that incident on direct examination, not once did she talk anything about the fact that before she'd gone over there to drive her car into the door, about going over to Coral Reef and what she had done over there, about having her temper tantrum over there, smashing the sliding glass door, pouring it on the carpet, and lighting it on fire. Those were just details that were conveniently left out. Examination about the fact that she had taken a knife with her when she went over there to confront Dan that day. Nor did she admit that she did know about the negotiations between Dan Jaffe and Dan Broderick regarding the sale of the house. That she did know that Dan Jaffe had gotten her what she claimed she had wanted. That she did know the house was to lie, and look at what she wanted out of that. And it's clear. She knew the house was going to be sold. She didn't mind it was going to be sold. All she wanted was more than 50% of the split. But the story you heard on direct examination was only that Dan Broderick sold the house out from underneath her with no notice to her, and she was in a state of absolute shock, panic, and terror. If there had been no cross, if there had been no one asking her some additional questions about that, her friends were in, hearing just those parts of the story. What's important for you to realize is that whenever Elisabeth Broderick tells you a story, you can be assured that you are not getting the whole story. Even Dr. Dietz testified about, and Dr. Dietz, by the way, reviewed all of the records, defense and from the people. He reviewed all of the documents and all of the testimony. He reviewed all of the prior psychiatric treatment. The only additional testimony that he read was Elisabeth Broderick, because he's the one that he was evaluating, and the psychiatric testimony, because there weren't any reports from them. And he said, irregardless of the actual truth of things, it was very noticeable that whenever there was a story of Elisabeth Broderick, that there always seemed to be, from other witnesses, another side to that story. She is very good at telling you this story. She is incredibly good, and her attorney is very good at repeating it. But it is a story, and it is a selectively chosen story. When you challenge that story with what other people have witnessed and said, then her response was, well, they're all lying. Everybody is against me. They're all telling this stuff about me. Everybody is lying about me. Everybody but me. And this isn't just about what happened in the bedroom. This is about all of the background. And there are lots of examples of that. For example, when Gail Forbes testified about her bragging about being a marksman, it was an incident back when they were in, that never happened. Nothing even close. Didn't happen. When Patty Monahan testified that shooting to the defendant, that never happened. When Sylvia Cavins testified that the defendant had told her she had a gun, she'd been practicing with the gun, and she was going to shoot Dan and Linda at the wedding. According to the defendant, that never happened. When Linda David testified that the defendant had told her how she was going to make Dan's life a living hell and going to murder him. According to the defendant, that never happened. Not maybe I was just joking, maybe she misunderstood. That never happened. When Robin Tuua testified about the incident where she'd been confronted by the defendant, and the defendant threatened her and told her she had a gun in the glove compartment. According to the and by the way, defense counsel says police officers take police reports when crimes have been, didn't go and get the gun and take it out and point it at Robin Tuua. She just told her, and the police would have listened, but they wouldn't have necessarily. When Helen Pickard and Gail Forbes and Patty Monahan and Sylvia Cavins and Linda David, when they all testified that they talked to her about the language that she was using with her children and how she was treating them and how harmful that was to their kids, according to the defendant, that never happened. That never happened. In fact, she says they're the ones that use that kind of language in front of their children on a daily basis. When Steve Sparta testified that he called Elisabeth Broderick, and when she was asked that question on cross-examination, that never happened. Sparta was just hired as a hired gun by Dan Broderick in this. He told Dan Broderick he wasn't going to get involved in a custody battle. And Dan hired him anyway to help these kids. When Bill Hargraves testified that he had any orders, that it was hurting the case, that it was going to cause problems with resolving the case, that if she didn't stop, she was going to go to jail. According to the defendant, that never happened. She completely denied it. When Bill Hargraves testified that she had called and complained about Attorney Glucksman filing a motion for custody against her permission, according to the defendant, that never happened. When Gail Forbes testified that she'd called her from jail that day of the Blackstone Ball and told her to call the newspapers and tell them about Dan being at the Blackstone Ball and her being in jail, according to the defendant, that never happened. Why would Gail Forbes make something like that up? When Liz Armstrong testified about her telling her about being offered a job at an investment company and not taking the job because she wouldn't go through the training program, never happened. Why would she make that up? When Helen Pickard testified that she and her husband had made investments with the defendant and Dan Broderick prior to separation, and they talked about it, they made investments together. According to the defendant, that never happened. She was specifically asked about the investment in Pioneer Park, which was an investment with Helen Pickard. The defendant said, "I know nothing about that." Well, look at the documents. There's a document that's been introduced into evidence, the subscription agreement by Dan Broderick and Elisabeth Broderick in her own signature, November 13th, 1980, 5 years before. Checks included where they were receiving money off of that investment in 83 and 85, where she endorses the back of the checks. She knew about these investments. How can you have any feeling that there's any credibility in the rest of her testimony that she didn't know about any of the investments that Dan was making? Examination, she testified that Dan was jerking me around with support in all of 1987, not paying late in the month, making me go back to court. Well, look at the documents. That is absolutely not true. He was paying her every month. He was paying her at the first of every month. He was paying every ride that Dan and Jerry Berry or having coffee with Judge Abbott in the mornings before court. It's not true. I've seen in chambers from the courtroom. She listed a whole list of things that she was upset about right before November 5th that was building this horrible depression of hers. She said she was so upset the week before. Dan was withholding money from my checks again. Look at the checks. Look at the check from November, from October, from September, from August. Every one of them, $16,000, the full amount. She received $64,000 in that 4-month period before she killed them. On direct examination, she testified she was so upset about her financial situation. It was getting so bad she had to sell the house. On cross, she admitted, because she knew she had to, that her accountant had actually told her she could probably keep the house and the condominium as an investment. She wasn't in any major. So upset because Dan was unilaterally switching her weekends, and it ruined her ability to be with the children on that planned weekend trip for Acapulco the weekend before these murders. That's a lie. That didn't happen. Look at the order that's been introduced into court. The weekends that were switched, and not unilaterally, her attorney was there, had nothing to do with that weekend when she was planning to go to Acapulco. That has got to make you have some sort of doubt about all of these claims she was making to her friends in the past about Dan switching weekends. It was a lie. There's also a letter. I never knew what weekends I would have or when I would have the kids. There's a letter where Jerry Berry, his attorney, sends a letter to her and says, please let us know what weekends you want, what weeks you want, so we can have this settled. She wouldn't respond. There's an instruction that you will hear that says, a witness who is willfully false in one material part of his or her testimony. You may reject the whole testimony of a witness who willfully has testified falsely as to a material point, unless from all the evidence you believe the probability of truth favors the testimony in other particulars. You think has distorted the truth to you. She claims she was so upset that week before because of Kim's call, that Kim called for the apartment in Tucson. Kim's testimony was, that's not true. I called my mom and we talked about it. I wasn't upset. Listen to the tape message that corroborates that. When Kim left a message on her machine and she's laughing. This wasn't a life or death matter. Elisabeth Broderick wants you to believe that her world was falling apart in late October and early November, and it's just not true. You've got to think about motive. You have to think about her demeanor and how she testified. You have to think about the inconsistencies in her own testimony. You have to think about the lies that have been proved by other evidence. Probably the most important was said. Defense counsel talked about using common sense, and I absolutely agree. Does what she said make sense? Do you really believe she didn't know whose keys those were that she used that morning to break into that house? Her testimony was, I didn't know where those keys came from. They just happened to be in my house. I didn't know who they belonged to. I didn't know what they went to. They were completely strange keys. And somehow they just happened to end up in my car, despite the fact that I didn't know what they went to. And then driving there was key, this point that these the keys, that those were Kim's keys, even though Kim's keys had disappeared only weeks before.
Okay. The next trial, the Brooks, is going to be better. Because it's going to be off of YouTube and not off the stupid Court TV website. I'm still here. It's still me. It's my picture and not actual me. It seems to run better that way.
And she's claimed she was in this alleged state of such tremendous distraught that morning, and yet she's thinking there in the car about looking for the box to find the key. It doesn't make sense. Do you really believe her story about the gun? She's got to come up with some explanation for somehow conveniently having that nice loaded gun there in the car. She says, I carried the gun in my purse whenever I had the boys because it was the safest place for it. The safest place for a loaded time. Anybody who is concerned about safety and concerned about their kids in relation to safety and a gun, and she had reason to be concerned. She admitted that Danny tried to steal that gun when he found out that his mother had bought a gun and was threatening to kill his father with the gun. He took it and ran out of the house with it. She knew that. And she's carrying around a loaded gun when the boys come over? She could have easily locked it in that locked room that she had. There's no evidence that she didn't have any way of getting into that locked room that she kept bolted up. That's where she kept her silver. That's where she kept her crystal. That's where she kept her jewelry. That's where she kept her wine bottles, according to Lee. She could have locked it in the trunk of her car. She could have given it to Brad to take it away when the boys were there. She could have hidden it somewhere in the garage. She carries around a loaded gun in her purse. And besides that, she didn't just keep it in her purse. She took it out of the purse and put it in her pocket when Dan Broderick was coming over. A thing to do, put it in your pocket when your kids are there, when Dan Broderick's coming over. She, even if Danny once went up, wrapped his arms around her because he was so concerned about what she was going to do. And then, just like the keys, the gun just happened to be in the purse, and the purse just happened to be in the car that morning. None of this was intentional, ladies and gentlemen. This was just convenient coincidence. This is where your common sense is much more reliable than the testimony of someone who has absolutely nothing to lose by lying to you. And if she's distorting the truth about these things, you can't accept the credibility of anything she has to say. I'm going to talk a little bit about the shootings and some of the things that defense counsel said yesterday. He emphasized with a very nice, beautiful chart there, the fact that there was movement on the bed by Dan and Linda when they were shot. Any difference? He talked about it, and he talked about it all in connection with there being reasonable doubt. And ladies and gentlemen, you have to have reasonable doubt about whether or not they were moving. Well, I agree. I don't dispute that at all. I don't think there's any way to know exactly where Dan and Linda were when they were shot. Elisabeth Broderick is the only living survivor that came out of that room. We don't even know whether she didn't go in the room and actually hold them there at gunpoint while she said her piece before she shot them. Maybe that happened. Counsel mentioned Paul Doherty, who Paul have an opinion that he believed it was possible that Elisabeth Broderick shot at them from the position on the one side of the bed and then went around the bed and last who was lying down. He thinks that's possible. If they accept their culpability, if any come around the bed and plunk the last bullet into him over there.
Because I think the reason why it matters if they moved, I think, is because she's trying to say, I think the prosecution is trying to say that they were asleep, and the defense is trying to say that they were awake and sat up in bed and said stuff to her. So it would be worse if she walked in there and just shot into sleeping people. But I don't know. I guess. But then she just said that she could have held them at gunpoint and said her piece to them. So I don't. You're right. I don't know, Wiggles.
Gene Wolberg, actually, the people's expert, took the most conservative view, that she was standing in the same point when she fired all of these shots. What we do know, without any doubt whatsoever, is that before they were sound asleep in bed, and when she left the room, they were dead or dying. We know without any doubt. There was no evidence that he moved after he, because of the way he was wrapped up in the blankets. When you look at Dan's body, you can see the blood tracks from his bullet wound, and you can see that he had to. He did some blood is dripping in one direction, the blood is dripping down in another direction. There had to have been a point where he was up, probably reaching for the phone to make that blood drip in that direction. Then a time to make it drip in the two different directions. And it's very reasonable to believe that when he was still alive, that he reached to take a look at Linda to see what her condition was, to see if she was dead, and perhaps coughed and left that blood splatter. Counsel talks about Dr. Swalwell and that there was a change in Dr. Swalwell's testimony. That's not true. In case you haven't or didn't notice during the course of this trial, defense counsel has a way of asking very convoluted and confusing questions to people. The testimony before by Dr. Swalwell was that he believed the wound through Dan was a through and through wound, and all that means is the bullet went in one side and out the other side. His testimony here was the same. He believed it was a through and through wound. The only difference was that he hadn't been given the opportunity last time to say there is a possibility that actually going through, the bullet might have stopped right in his chest, and then when he fell off the bed and hit the ground, went out. That's a possibility. That's testimony, and it has no significance. I mean, either it went through and through, or it popped out when he fell to the ground. These are false issues. To buy the defense that Elisabeth Broderick is guilty of voluntary manslaughter, it's a given. You have that Elisabeth Broderick is only guilty of voluntary manslaughter. It's a given. You have to buy her credibility. But even putting her credibility aside, the problem is that the way that her conduct, sneaking into their room that morning, qualifies as voluntary manslaughter. It does not qualify under the law. The law was not explained to you in its entirety yesterday when there was talk about voluntary manslaughter. There's essentially three parts to it. Voluntary manslaughter under a heat of passion theory is when someone doesn't have a murderous thought in their body. And all of a sudden something unexpected happens and it catches them off guard. They react with a murderous impulse. They react immediately without any time to think about it. They react reasonably. Other people in the same circumstances can see themselves reacting the same way by killing because the provocation was so extreme. The classic text example of voluntary manslaughter that probably all of you and every law student learned is the man who thinks everything is going great and he comes home one day to find his wife in bed with another man. And he's shocked and he's horrified and he grabs a gun on the dresser and he shoots. That's heat of passion, voluntary manslaughter. The continuation of that classic example, textbook example, is that if instead of shooting, he had simply left the house, he went over to a friend's house, maybe in the evening, talking about what had happened. Maybe he was even getting angry and angrier as he was remembering and reliving what happened. And so the next day he decides he's going to buy a gun. And he goes and buys a gun. And he goes over to the lover's house. And he knocks on the door. And the lover opens the door and he shoots and kills him. That's murder. He may still be very angry and he may still be very upset, but he's had time to realize that killing is not the appropriate option. Defense counsel arguing to you that this is voluntary manslaughter is that voluntary manslaughter requires an intent to kill. Every person who unlawfully kills another human being without malice aforethought, but with an intent to kill, is guilty of voluntary manslaughter. Elisabeth Broderick says she did not intend to kill. She says, I just wanted to talk. I was going to kill myself. I wasn't killed. I just panicked. I flinched and shot. It was accidental. I didn't shoot them, let alone kill them. There is a major inconsistency between what she says happened and what her attorney is arguing to you. If he's arguing for voluntary manslaughter, ladies and gentlemen, he is conceding to you that she had the intent to kill. That when she went over there that morning, it was for the times attorneys would like their clients to say different things so that they could have a better legal argument to a jury. But this isn't some intellectual game here. This is real. This is about if you believe Elisabeth Broderick that she didn't intend to kill, then she's guilty of second-degree murder under an implied malice theory. If you don't believe Elisabeth Broderick, she's guilty of first-degree murder. There was a brief mention, by the way, I should mention this, about involuntary manslaughter. You will see an instruction to that simply because under the law of homicide, you get all lesser included offenses. That doesn't mean it applies. In fact, it was never argued by the defense because it doesn't. That involves a situation, usually very tragic situations, where someone is committing a minor crime and a tragedy occurs. For example, carrying a loaded gun and a child grabs it and shoots it and kills someone. That's obviously not the situation here. It's even conceded that Elisabeth Broderick broke into their home with the intent to assault them with a burglary and an assault with a deadly weapon, and those are felonies.
Yeah, that is not the definition of it. That's
Sustained.
Involuntary manslaughter doesn't apply here. It wasn't even argued here. The other thing that I want to point out, too, before I forget, is there is an allegation that you're going to be asked to make a finding on, allegation of a personal use of a firearm. It's called 12022.5 under the Penal Code. And all that means is that you make a finding that, yes, she did personally use a firearm. And it doesn't matter what you find her guilty of. She obviously used the firearm. There's no dispute on that. The other problem with arguing for voluntary manslaughter is that even if you ignore the defendant's denial of an intent to kill, you still have to find that she was acting as a reasonable person in direct and immediate response to an adequate provocation. Passion from murder to manslaughter, the killing must have occurred while the slayer was acting under the direct and immediate influence of such quarrel or heat of passion. This is crucial. The defendant is apparently claiming that that letter that she received, the letter that we've been talking about, that was written by Kathy Cafaro to her attorney Walter Mond, that she writes on, that talks about the messages she's been leaving, that was the last in a string of all sorts of provocation that supposedly set her off in this blinding heat of passion. The problem is there was no immediate response to that letter. She received that letter, even by her own admission, at least 2 days before. She received it on Friday. Lee confirms, her daughter Lee confirms that when they went shopping on that Friday, that she was talking about that letter. That she was telling her she was angry about receiving the letter. She was angry because your dad is threatening to take me back to jail again. She'd read the letter. She knew in the letter. On Friday, she didn't respond in any uncontrollable heat of passion. On Saturday, when she's talking to Helen Picard, she's talking about the same thing. She's angry about the letter from Dan. He's threatening to take me back to jail again. On Saturday, any uncontrollable heat of passion. She's going about her business on Friday and Saturday. Even giving the defendant the entire benefit of the doubt that she didn't read that letter until Sunday morning, even her own testimony is that after reading the letter, she didn't immediately rush off and do anything. She sat down and wrote on the letter. That's when she claims she sat and wrote this little note letter. That's when she sat and wrote and typed to Kathy Cafaro. She obviously wasn't in the throes of some impulsive, uncontrollable, murderous heat of passion if she could sit down. And this letter is completely intelligible. When you look at it, it's very angry, but it's certainly coherent. The handwriting is normal. It's no different than her other handwriting. There's nothing wild about it. And it is interesting where these letters are found. She claims she wrote both these letters. She wrote on the one letter sent to her. She wrote the letter to Kathy Cafaro within moments of each other. But look at the photographs of how things were when they were found and seized. This one in particular, this is the letter here on this side from Kathy Cafaro. And this is the letter over here that she wrote to Kathy Cafaro. And it's got another note on top of it, and it's got a paperweight on top of it. Did she write it and put this other paper and the paperweight on top before she rushed off in an uncontrollable heat of passion? Why did she write one on one side of the counter and the other on the other side of the counter? I suggest to you, because she wrote one of these letters, and probably this one to Kathy Cafaro, a couple of days earlier. And what that means is there's absolutely, she knew in that letter from Kathy Cafaro when she wrote it. And also, by the way, that letter says nothing about the kids. It says nothing about we're not going to give you the kids, or I'm not going to, or I'm not going to have any more hearings, or I'm not going to negotiate anymore. All it has to do with is her leaving more messages on the answering machine. The fact that that letter was the last of an alleged series of events does not do away with this absolute requirement of immediacy, of responding immediately before you have time to react, before you have time to cool down, reacting immediately before you have time to reflect. The fact of the matter is that she had all the time in the world to reflect that morning. She was sitting there in her kitchen reflecting before she went over there and did this. Even assuming that receiving a letter can possibly be adequate legal provocation of someone, she's the one who set the timetable here. She's the one who chose the time. She's the one who chose the place. She's the one who armed herself before choosing the time and place. She's the one who had the opportunity to stop, to change her mind right up until the very instant that she killed him. This cannot be voluntary manslaughter. In addition to the fact that there was no intent to kill, according to the defendant, in addition to the fact that there was no immediate response to anything, there's also another extremely important requirement for voluntary manslaughter, and that is that the defendant be acting as a reasonable person of average disposition. The heat of passion which will reduce a homicide to manslaughter must be such a passion as naturally would be aroused in the mind of an ordinarily reasonable person, in the same circumstances. A defendant is not permitted to set up her own standard of conduct and to justify or excuse herself because her passions were aroused, unless the circumstances in which the defendant was placed and the facts that confronted her were such as also would have aroused the passion of the ordinarily reasonable person faced with the same situation. Even assuming the absolute truth of everything she says about the whole course of events here, there's uniform agreement everyone for a long time. Her continued rage, her refusal to let go, her obsession in Dan and Linda that continued year after year after year was unreasonable. This is where the testimony of the psychiatrists come in and have some important challenge of Dr. Dietz. I think unfairly. Dr. Dietz testified, he has testified, goes prosecution, neither side and buys his testimony. His reputation wouldn't be so nationally known if that were the case. But it doesn't really matter, because the fact of the matter is there's not much difference between the testimony of Dr. DeFrancesca and the testimony of Dr. Dietz about the defendant. Dr. DeFrancesca said, and this is psychological stuff, that she believed the defendant had a borderline personality disorder, narcissistic and histrionic characteristics. Dr. Dietz said, I believe she has a narcissistic personality disorder with borderline characteristics. They're basically saying the same thing. It's all in this same cluster of personality traits. And it's not the that she's insane. It's not that she's mentally ill. It's not that she doesn't know exactly what she's doing. It's not that she has any impairment in her ability to choose and plan. Simply as it where she reacts in it are people who overreact to the smallest slight. That was Dr. DeFrancesca's own testimony. With an average disposition. They are mutually exclusive. But I don't think you need to have psychiatrists or psychologists tell you whether or not she was acting reasonably during this period of time. Even her 11-year-old son, Danny, saw that she was not acting reasonably. When you listen to that tape, Danny was living these circumstances. And he saw what was going on. He saw what his mother was doing. He saw the unreasonableness. He saw the distortions. He saw, for example, that she only appeared to care about the money. He says it several times in there, at least more than her kids, that their marriage had been bad for years, and it wasn't just his dad's fault. He saw that it wasn't his dad's fault that they were living with him, that she dumped them. He saw that he was making lots of money, that she had lots to spend, that she had a beautiful home, she didn't need more money to be happy. He saw that. He saw that it was her conduct, not his dad's, making things bad for him, that was making them all miserable, and that she was the only one who could change that.
Chill. I think the paper bags have evidence in them.
Time. And that was long enough. And he also saw that she was going to stay mad. The last sentence in that tape, he says to her, you want to be mad another 2 years, another 4 years, maybe another 6. And he was right. And the little boy pleaded with mother in every way that he knew how to make things better for him. Because I hate Daddy. Because I'm ticked off. Because I haven't been mad long enough. What is clearly going on in that conversation is she is saying, forget about you, Danny. My anger.
Well, it's just proper rebuttal line overall. You can comment on this.
Your Honor, but she only commented on the way that is allowed in. Just like I'm only allowed to comment on things the way they're allowed in.
That's what she's doing, Mr. Wood. Go ahead.
My anger is more, that's what she was saying. Ordinarily reasonable people do not emotionally sacrifice their children in such extreme ways just because they're angry, justifiably or not. Dan Broderick didn't cause her to do that or to be that way. He pleaded with her not to. Linda Broderick didn't cause her to do that or be that way. It was her choice. It was her choice to stay mad. It was her choice to act out on the anger, just like it was her choice to ultimately kill him. Not only do we not have an intent to kill, not only do we not have an immediate response, not only do we not have someone who was acting as a reasonable person, also adequate legal provocation of a kind that is going to naturally arouse an act of killing. And this is, of course, where you've heard all of the bad stuff about Dan and Linda. It is a simple fact, a very unfortunate fact, but true, that the vast majority of the defendant's testimony, 95% of it, 95% of this case, certainly about the relationship, her relationship with Dan, years before these killings, cannot be rebutted. These were things that if they happened between the two of them. And he's not here to say otherwise. He is fair game. He cannot rebut.
Your Honor, I'm going to object.
Counsel!
I did not bring that. I object.
Whoa! I did not expect that. Dang.
Go ahead.
Linda Broderick is dead. She's been wanting to have the opportunity. They hurt her. She's been wanting to have the opportunity to hurt them and to tell this story about them. In one of those taped messages, she said, quote, "I want to go to court to prove that you're a fuckhead and she's a cunt." She tried at the divorce trial, and she wasn't allowed because it's no-fault divorce. It's not at issue. Well, now she has a captive audience. She's got you. And not only you, but all of the newspapers and the reporter people who wouldn't really pay too much attention to her before, well, they're here now, and they're listening now, and she's getting her opportunity to prove that Dan Broderick was what she said he was, and Linda was what she says she was. Well, ladies and gentlemen, everything Elisabeth Broderick wants you to believe about Dan and Linda Broderick, whether they are actually true or not, whether they're taken out of context or concede. I am not going to argue about it with her or with you. I'll concede that Dan Broderick was wrong in leaving his wife. No man should ever leave their wife, and no woman should ever leave her husband, especially for someone else. I agree. It's rotten. In a perfect world, it would never happen. In a perfect world, marriages would last forever. They'd all be blissfully happy. No one would ever fall in love with anyone else. And if he was going to leave her, he probably should have left her back then in 1983, when it was clear that he was unhappy. I'll concede that he should have given her more money during the course of this divorce. He should have given her everything. That assumes the testimony from witnesses that in 86, 87, 88, 89, for example, she had a closet full of clothes that still had the tags on them. Would another closet full of clothes with tags on them have made a difference? She had a Jag, she had 2 other cars. Would another Jag in the garage have made any difference? She was able to travel extensively and live in a $1 million home Would another trip to Hawaii or Tahiti or San Francisco have made a difference? I'll concede that he should have given her the kids every time she asked for them, no matter what she was doing. No matter whether she had given them to him in the first place, no matter whether she was refusing to take them, no matter whether the psychologists were saying her conduct was harmful. And by the way, there was a lot more to what she was doing to those kids that was significantly harmful than just calling their father a bad name. But maybe he should have declined to exercise any control over that. I'll concede that Linda should have never gotten involved with him. She should have never loved him. She should. But those verdict forms that you're going to get don't read, "We, the jury, find that Dan and Linda Broderick were..."
Whoops. I was gonna go back so Judy could watch it again, and I screwed it up. Sorry, guys. Stop it! I hate this website. Have I told y'all how much I
San
hate this
Francisco
website?
have made a difference. I'll concede that he should have given her the kids every time she asked for them, no matter what she was doing. No matter whether she had given them to him in the first place. No matter whether she was refusing to take them. No matter whether the psychologists were saying her conduct was harmful. And by the way, there was a lot more to what she was doing to those kids that was significant.
Yeah, only every day, but you guys keep coming back. I'm not worried about it. You keep coming back to watch it, even though I hate it,
Gotten involved with him.
and it causes problems.
She should have never loved him. She should have never married him. She should have never responded in any way to Elisabeth Broderick's taunts and threats and name-calling and venom and the things she was telling her children to do to her. She should be. But those verdict forms that you're going to get don't read, "We, the jury, find that Dan and Linda Broderick were or were not perfect people." They don't read, "We, the jury, find that Dan and Linda Broderick did or did not deserve to die, not guilty of an act of murder." When you talk about provocation here, you have to think about what the actual credible evidence of provocation is that's been presented that justifies killing. There's been so much talk about this crazy making of the defendant. Whatever the events were that happened in that marriage, by her own testimony, this was a marriage that she wanted very, very badly to continue, even after knowing about the affair. The events of the marriage, which were 5 years before these murders, had nothing to do with what happened on November the 5th.
The shell broke at that time. Ellis? Who was Ellis? Is that the crazy lady? I'm not doing the crazy lady. The one that stabbed a toddler? I don't want to do her. Is that Ellis? If you guys want to watch it, I'll do it, but I don't want to do it. Yeah. I don't want to do her. Can we not do her? Can we please not do her? Oh, poor BK. I was going to finish this. We're going to finish Betty today, and then I was going to start Brooks. Brian Walsh's trial starts on the 20th. I need a break from dead kids, y'all. I'm sorry. And this lady... Yeah, and this lady was crazy. Like, there was, like, some altercation about a shopping cart or something. I don't know the whole story, but she's crazy. Like, she just stabbed the toddler for no reason. And, I mean, that's her defense, is insanity. And you can look at her picture and tell she's nuts. And I just... You guys hash that out in the chat. I'm not even touching that one. But, yeah, this woman... I mean, I feel for people that are that mentally ill, but at the same time, she needs to be locked up for the public safety, but I don't need to hear the details of her stabbing a toddler. So, yeah, I really don't want to do it. I'm sorry, guys. If you guys really, 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 really want to see it, I'll do it, but I don't want to do it. This is true, Wiggles. We're all crazy. It's just a matter of degrees.
It happened on November the 5th.
We're fun crazy here, though. Yeah, we're fun crazy. We're the good kind of crazy.
Counsel argues about going through this long and bitter divorce, that this is provocation. Nobody is saying that it is a great thing to go through a divorce. I think everyone can feel compassion for someone who is being divorced who doesn't want to be. Nobody is saying she didn't have the right to hate Dan and Linda for the rest of her life. But if going through a divorce and not getting exactly what you want is enough to justify killing the other side, then our streets are to be filled with bodies. We have a whole family law courthouse that is filled with people going through long and bitter divorces on a daily basis. And the fact of the matter is, if there was someone who was obstructing the settlement of this divorce and dragging it out, it was Elisabeth Broderick. That's the evidence that's before you. And the testimony of Bill Hargraves, her attorney in 1986. He was representing her over a year and ethically telling him she didn't want to settle. She wanted to drag it out. She thought she was going to get him back. Defense counsel talks a lot about all that Elisabeth Broderick went through in this divorce. I think you need to think about what this case is not. You need to put it in perspective. This case is not about a woman who was truly left with no money, broke and penniless. And there are lots of women out there who are abandoned by their husbands, who have 4 and 5 kids to raise, who have no source of income, who have no educational background to get a job, to do anything, no support at all. Elisabeth Broderick had available to her for her use and enjoyment more money than probably 95% of the people in this room. Maybe even 100%. She testified about that, about how I was so alone and I had no one to talk to.
She needs
And
to be
then
locked up.
they ended up putting on a whole series of witnesses, friends, to say how they had for her and been supportive. She had a tremendous number of friends and family. She had the money and the ability to seek out and join support groups and organizations and invest clubs. She had places and being supportive. Dan Broderick was not controlling her every moment. She was free to work. She was free to go to school. She was free to travel. She was free to choose her own friends. She was more financially independent than most people you'll know. This is not a situation where she was forced into having no adequate legal
Yeah, she needs to go to a mental health facility and be locked up for the safety of the public. The baby didn't do anything. She just, and I don't even know if whatever the incident that happened in the parking lot had anything to do with the family of the baby. But she just, there is surveillance video of her walking into the store with a knife, and I don't know. The altercation happened in the parking lot. I don't know if she had already stabbed the toddler in the parking lot, because I don't know all of the, yeah, I haven't watched all of it. I just saw like a little snippet of it, and I was like, oh no, we're not watching that. I'm not watching that. I'm sorry, guys, about the technical issues. I don't know why it's so bad today, but we'll be done with this website that I hate after this, and we're going to do Brooks from YouTube. And like I said, Brian Walsh is coming up on the 20th. I have got some of his hearings and stuff that we missed bookmarked for saved for later, whatever it's called, for us to watch. I guess we can do that later in the week, because I'm I'm wanting to get to Brooks really bad. There is another hurricane out there. Hurricanes have been the bane of my existence this year. Because they're not, usually they come and then we lose power for a couple days, but we have a generator, so it's okay. So we lose power for a couple days. Usually Travis gets off work because there's no power in town for at least a day. So we get extra time together. And then it goes away. And then we have nice weather for however long until we get the next hurricane. But all of the hurricanes this year have been off the coast. So we've gotten rain every single day. I swear it has been every single day since the beginning of the summer. And now it's fall and we're still getting rain every single day. It's awful. It is so depressing. It's every day it rains. Every day. And I'm ready for it to stop.
Adequate legal representation in a divorce. And there are people out there who are in that sort of financial quandary who can't hire an attorney. Elisabeth Broderick had 4 attorneys, all very competent. She had the money to pay them. She had the option of keeping every one of them. She's the one who chose to fire them. And this argument about Dan Jaffe and the retainer fee is very misleading. The reason she was given more than 50% of the proceeds of Coral Reef was so that she would have the money to pay that retainer. She chose to invest it instead. I mean, she's complaining Dan wouldn't pay the retainer. She's got $100,000 that she goes and invests. She could have paid a retainer to Dan Jaffe if she wanted. She told Amy Wallace she fired him because she wasn't happy with his actions on her behalf. Not because of the retainer. None of them were good enough for her. She fired Bill Hargraves because he wasn't tough enough. He wasn't making life difficult enough for Dan Broderick. She fired Tricia Smith because Tricia Smith was kissing up to Dan. And Tricia Smith was going forward on that divorce. The evidence is that she had hired an accountant. She had taken depositions. Excuse me. She had hired an expert to evaluate his practice. And boom, she's fired by Elisabeth Broderick. Dan was not pulling the delaying tactics here. She was. The fact of the matter is that after January of 1989, she was actively represented by an attorney, Mr. Walter Mond, who was going to court for her, who was filing motions for her, who was getting orders for her. She had some stuff for her. She had to do her confronting for her. She didn't need to do it, and she didn't need to do it with a loaded gun. She complains that Dan got restraining orders against her, and he filed contempt actions against her when she violated them. But she acknowledges that she was smashing windows. She was painting, burning houses. She was messages. When she did this stuff over and over and over, Dan could have gotten angry and charged over to her house and retaliated in kind. He could have slashed tires, smashed her windows. He could have threatened to kill her. He could have threatened to beat her up if she did again. Or he could do what the law says to. Seek the assistance of the courts. Have a judge decide what's appropriate and what should be done. Is that provocation that justifies killing? Would she be justified in killing Judge Joseph too because he ruled against her? This specter of Dan Broderick and his power because he was president of the Bar Association, that was in 1986. Nothing was being litigated in 1986. There was one hearing and one hearing only because the defendant wasn't responding. And that was in December when she was represented by Bill Hargraves. There was another president of the Bar Association in 87, and another one in 88, and another one in 89. And if you walk out into this courtroom, or this courthouse, and you ask 10 lawyers who the president of the Bar Association is, 7 of them will tell you they don't know. Where was this continued crazy making by Dan Broderick? Where's the actual evidence of it? When you look at 1989, there were 2 hearings in court that she did have to go to in March, both. One was after she stole the wedding list. The other was because she'd kicked Lee out of the house after being awarded custody. She talks so much about the things that Dan was doing to her and never wants to address what she was doing to cause that response. There was nothing after that by Dan Broderick, no contempt. Don't get confused with all this stuff that was happening years earlier. And when there was that litigation, counsel showed you on the board for 1987, that's when she'd hired Tricia Smith, and half of those things are things being filed by Tricia Smith on her behalf. This claim, the claim that is being made to you with very little factual support and no legal support, is that Dan and Linda drove her to this. That's like blaming a rape victim for being raped. That's like the defendant saying to the judge, if she hadn't have been walking down that dark street all alone in a short skirt, it wouldn't have happened. It wasn't, judge. She tempted me. Probably true, she shouldn't have been walking down a dark street all alone. But does that excuse him? That's exactly what Elisabeth brought there. He's the one who divorced me. It's not my fault. They made me mad. Well, you're not going to hear any instructions from the judge that says murder is okay just because you're mad, justifiably or not. Her actions don't qualify for voluntary manslaughter under any of the legal. One of the very important other instructions that you're going to receive regarding voluntary manslaughter is that to reduce murder to manslaughter, the provocation must come from the actual victim. No matter how overwrought or how reasonably impassioned someone is, unless the provocation is specifically from the person you kill, it cannot be manslaughter. I mean, when you talk about this letter, for example, the letter, it didn't even come from Dan Broderick. If Dan Broderick wanted to provoke her, he could have written her a letter. He'd written her letters in the past. He was trying to avoid provoking her. Her attorney, Kathy Cafaro, wrote the letter to Walter Mond. It was Walter Mond's decision to forward this letter to Elisabeth Broderick. Kathy Cafaro, she says, well, it came from Dan. The letter she writes in response to it says, Dear Miss Cafaro. What this also means is that no matter, you've got to separate what you're looking at with respect to count 1 and Dan Broderick and count 2 and Linda Broderick. What about Linda? Linda Kolkena Broderick. So much of this trial has focused on Dan Broderick, Dan and Elisabeth Broderick, and his power and his influence and their relationship and their divorce. Linda has almost become a forgotten victim. Mr. Early spent 4 hours talking yesterday and probably spent maybe 5 minutes out of that talking about Linda. Well, you can bet that her family and her friends have not forgotten that she's a victim. Linda was a separate human being who is the legitimate, actual, legal provocation that's been proved that independently justifies a reasonable person in killing her. And there's been a mention of a few things. I'll mention them quickly, that her voice was on the machine, her own voice on her own phone machine in her own home that says, "Hi, you've reached the Broderick residence. We're out and about, so leave a message at the beep." There's no question that the defendant didn't like that. It irked her because it's so no question that she just didn't have the right to control that anymore. They were married. She knew the voice obviously wasn't in. She had years to get used to that Linda wouldn't give her the wedding china, that Kim testified that she'd always hated. I mean, in a vacuum, it probably is pretty easy to say, why didn't she just give her the wedding china so that she couldn't have this thing to complain about? Living through the demands in 1985 and 1986, 87, 1989, not reasonable. No more. That she allegedly sent this note back in 1986 that says, "Eat your heart out, bitch," on it. That she allegedly sent her wrinkle cream ads that somehow have never been produced. Apparently never seen by anybody else. Certainly doesn't meet any immediacy requirement. None of these things that have been said, even if all believed, even all together, even multiplied tenfold, can possibly justify a reasonable response for months and months and months before these murders, other than being Mrs. Daniel T. Broderick. This cannot be manslaughter. Nor does the concept that I think might have been mentioned earlier in the case, that maybe Linda was simply in the wrong place at the wrong time, reduce the culpability of Elisabeth Broderick. Even if you believe that she went over there just because she wanted to kill Dan, and Linda somehow got caught in the crossfire,
Can you hear me? I got muted again. I'll be glad when we're done with this.
doesn't mean that the person who kills them isn't guilty of murder. It means they are. That's a perfect example. even if you buy that the defendant went over to kill Dan in a heat of passion, we kill him in a heat of passion, she still killed Linda too. And at a very minimum, she's second to murder for that, minimum. I submit to you that there is no question, however, that she did intend to kill Linda too. She hated Dan, that's clear. But she too. She had just as much motive to kill her. In fact, deep down inside, Linda was the real of it all. Linda was in the first place, and leave Linda as Mrs. Daniel T. Broderick with all of the money, with all of what she thought was her money. No way that she made sure one of them died. It was Linda. At least if Dan, at least her, and that's why she shot Linda first, and that's why she came back and shot her again in the back of the head. And you can look at the statements that she makes in the after that support that. Many of these are already gone over. But one of them was starting off with Dr. Robinson and how she was talking about Linda the very next day. Calling her the bitch, talking about how she was responsible for everything, talking about her with such hate and without remorse. I mean, this is not someone who just got caught in the crossfire. There was a conversation to Helen Picard a couple of weeks later when she's talking about what happened. And she's talking about how Linda was destroying my life. And Helen asks her, so you destroyed her? And her response was, yeah. Yeah. The statement to Maria Peralta, quote, in my for $7. That fucking bitch, she was living in my house, driving my car, sleeping in my bed. I doubt if the deputy sheriff, Maria Woods, ever got to Maria Peralta put the two statements together. These are not statements of accident or right mean to. They're statements of hate and motive and reason for killing. Counsel challenges the statements that the defendant made to Dr. Robinson the next day about being that she was essentially happy and that she was relieved. He talks about, well, what do you expect if he's looking at her to determine whether or not she's suicidal? Well, if those are not legitimate statements, then the only other alternative, the only other thing that means is that she was putting on a darn good act for Dr. Robinson, enough to fool an experienced psychiatrist, to get an achieved result. And if she was doing that with him, don't you think she can do that with you? And the interesting thing is, she makes the very same similar types of statements again about a month later in a conversation with Helen Picard, where Helen Picard's not testing her for a suicide watch, where she says, I've never been happier in my life. It had to end. There was so much unhappiness before. I couldn't feel better. She says to the nurse Hines the day after she asked whether it was suicidal. Her statement was, the situation is resolved. Defense counsel says, well, of course she's going to say something like, I'm okay, let me out. But that's not what she said. She said, the situation is resolved. I'm not suicidal. The situation is resolved. What does she mean by that? What situation? Certainly not her financial situation that she was so upset about. After killing Dan Broderick, that can't be better.
2 hours.
Certainly not the children's situation that she was so upset about. She's now in custody and can't be with them at all. Only thing resolved is dead. And then there's the statement, whatever the future holds, I'll be okay. I've chosen the path of peace, and I have finally found it. Killing 2 people, including the mother of her children, gave her peace. I told you at the beginning of the case that this wasn't a death penalty case. That's not true. This is a death penalty case. Elisabeth Broderick imposed the death penalty on Dan and Linda Broderick. They didn't get to present their case to a jury before they were executed. She made that decision on her own. She doesn't have the right to play God any more than any of the rest of us do. She doesn't have the right to decide who lives and who dies just because she's been hurt. It would be an absolute travesty to all the people out there who have lives, to all the people out there who take responsibility for their own lives, to all the people out there who have been held responsible for their conduct, and not hold her responsible for hers. Murder is murder. Going to someone's home and killing them in their bed is for that. Thank you.
Thank you, Ms. Wells. We'll take our morning recess at this time, ladies and gentlemen. We'll be in recess until 10 minutes to 11. Please remember the admonition. Matter of people of the state of California versus Elisabeth Broderick. Court finds all members of the jury panel are present. All counsel are present. Mrs. Broderick is present. For those of you in the audience, if any of you want to now, I don't allow people to enter or leave the courtroom while I'm reading the instructions. It'll take me approximately 45 minutes to read the instructions. So if that nature's going to call or anything, now's the time.
Okay, so not a whole 2 hours, an hour and 15 minutes. And the rest of the time is going to be jury instructions.
Before I start, ladies and gentlemen, I could tell you that it's my practice to send the jury instructions into the jury room with you, so it's not necessary to take notes during the instructions. However, ladies and gentlemen, the jury heard all the evidence to the attorney to instruct you in law. The law requires that I read the instructions to you. You must base your decision on the facts and the law. You have two duties to perform. First, you must determine the facts in the trial, a fact proved directly or circumstantially by the evidence or by stipulation. A stipulation is an agreement between the attorney
Damn it, StreamYard. Can we get to the end of this without more interruptions, please?
them, and in this way arrive at your verdict and any finding that you're instructed to include with your verdict. You must accept and follow the law as I state it to you, whether or not you agree with the law. If anything concerning the law said by the attorneys in their arguments or at any other time during the trial conflicts with my instructions on the law, you must follow my instructions. You must not be influenced by pity for a defendant or by prejudice against her. You must not be biased against the defendant because she has been arrested for this offense, charged with a crime or guilt, and you must not infer or assume from any that she is more likely to be guilty than innocent. You must not be influenced by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Both the people and the defendant have a right to expect that you will conscientiously consider and weigh the evidence, apply the law, and reach a just verdict regardless of the consequences. If any
Oh, she made him shut up and sit down because he was going to
rule, direction, or idea is repeated or stated in different ways in these instructions, no emphasis is intended, and you must not draw any inference because of its repetition. Do not single out any particular sentence or any individual point or instruction and ignore the others. Consider the instructions as a whole and each in the light of all the others. The order in which the instructions are given has no significance as to their relative importance. Statements made by the attorneys during the trial are not evidence. Although if an objection was sustained to a question, do not guess what the answer might have been. Do not speculate as to the reason for the objection. Do not assume to be true any insinuation suggested by a question asked a witness. A question is not evidence and may be considered only purpose. Any offer of evidence that was rejected or any evidence that was stricken by the court, treat it as though you never heard it. You must decide all questions of fact in this case from the evidence received in this trial and not from any other source. You must not make any independent investigation of the facts or the law or consider or discuss facts as to which there has been no evidence. This means, for example, that you must not on your own visit the scene, conduct experiments, or consult reference works or persons for additional information. You must not discuss this case with any other person except a fellow juror, and you must not discuss the case with a fellow juror until the case is submitted to you for your decision, and only when all jurors are present in the jury room. Evidence consists of testimony of witnesses, writings, material objects, or anything presented to the senses and offered to prove the existence or the non-existence of a fact. Evidence is either direct or circumstantial. Direct evidence is evidence that directly proves a fact without the necessity of an inference. It is evidence which by itself, if found to be true, establishes the fact. Circumstantial evidence is evidence that, if found to be true, proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts that have been established by the evidence. It is not necessary that facts be proved by direct evidence. They may also be proved by circumstantial evidence or by a combination of direct evidence and circumstantial evidence. Both direct and circumstantial evidence are acceptable as a means of proof. Neither is entitled to any greater weight than the other. However, a finding of guilt as to any crime may not be based on circumstantial evidence that the defendant is guilty of the crime, but they cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt. Also, if the circumstantial evidence as to any particular count is susceptible of two reasonable interpretations, one which points to the defendant's guilt and the other to her innocence, you must adopt the interpretation which points to the defendant's innocence and reject the interpretation which points to her guilt. If, on the other hand, one interpretation of such evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. The specific intent or mental state with which an act is done may be shown by the circumstances surrounding the commission of the act, but you may not find the defendant guilty of the offense charged in counts 1 and 2 unless the proved circumstances are not only consistent with the theory that the defendant had the right, but cannot be reconciled with any other rational conclusion. Also, if the evidence as to any specific mental state is susceptible of interpretations, one of which points to the existence of the specific intent or mental state, and the other to the absence of the specific intent or mental state, you must adopt the interpretation which points to the absence of the specific intent or mental state. If, on the other hand, one interpretation of the evidence as to that specific intent or mental state appears to you to be reasonable and the other to be unreasonable, you must accept the reasonable and reject the unreasonable. There has been admitted in evidence the testimony of mental health experts of statements made by the defendant in the course of an examination which were made for the purpose of diagnosis or treatment. Such statements may be considered by you only for the limited purpose of showing the information upon which the mental health expert based his or her opinion. Such testimony is not to be considered by you as evidence of the truth of the facts disclosed by the defendant's statements. Dr. Dietz testified on behalf of the prosecution regarding his diagnosis of the defendant. This diagnosis was not based on a personal interview of the defendant. However, Dr. Dietz had requested to be allowed for such an interview, and the court refused to order it. Neither side is required to call as witnesses all persons who may have been present at any of the events disclosed by the evidence, or who may appear to have some knowledge of these events, or produce all objects or documents mentioned or suggested by the evidence. Evidence that on some former occasion, a witness made a statement or statements that were inconsistent or consistent with his or her testimony at this trial may be a witness, but also as evidence of the truth of the facts as stated by the witness on such former occasion. If you disbelieve a witness's testimony that he or she no longer remembers a certain event, such testimony is inconsistent with a prior statement or statements by him or her describing that event. Every person who testifies under oath is a witness. You are the sole judges of the witnesses and the weight to be given to the testimony of each witness. In determining the believability of a witness, you may consider anything that has a tendency and reason to prove or disprove the truthfulness of the testimony of a witness, including but not limited to any of the following: the extent of the opportunity or ability of the witness to see or hear or otherwise become aware of any matter about which the witness has testified, the ability of the witness to remember or communicate any matter about which the witness has testified, the character and quality of that testimony, the demeanor and manner of the witness while testifying, the evidence of the existence or non-existence of any fact testified to by the witness, the attitude of the witness towards this action or towards the giving of testimony, a statement previously made by the witness that is consistent or inconsistent with the testimony of the witness. Discrepancies in a witness's testimony or between his or her testimony and that of others, if there were any, do not necessarily mean that the witness should be discredited. Failure of recollection is a common experience, and innocent misrecollection is not uncommon. It is also a fact that two persons witnessing an incident or transaction often will see or hear it differently. Whether a discrepancy pertains to a fact of importance or only to a trivial detail should be considered by you in weighing its significance. A witness who is willfully false in one material part of his or her testimony is to be distrusted in others. You may reject the whole testimony of a witness who willfully has testified falsely as to a material point, unless from all the evidence you believe the probability of truth favors his or her testimony in other particulars. You are not bound to decide an issue of fact in accordance with the testimony of a number of witnesses which does not convince you, as against the testimony of a lesser number or other evidence which appeals to your mind with more convincing force. You may not disregard prejudice or from a desire to favor one side as against the other. You must not decide an issue by the simple means of counting the number of witnesses who have testified on the opposing sides. The final test is not in the relative number of witnesses, but in the convincing force of the evidence. Weight you think it deserves. However, testimony by one witness which you believe concerning any fact is sufficient to prove that fact. You should carefully review all evidence upon which the proof of such fact depends. The various tapes, defendant and others, were used for the purpose of showing that the defendant committed an act other than that for which she is on trial. Such evidence, if believed, was not received bad character or that she has a predisposition to commit crimes. Such evidence was received and may be considered by you only for the limited purpose of determining if it tends to show the existence of the intent which is the necessary element of the crimes charged, and or a motive for the commission of the crime charged, and or absence of mistake or accident. For the limited purpose for which you may consider such evidence, you must weigh it in the same manner as you do all other evidence in the case. You are not permitted to consider such evidence for any other purpose. Within the meaning of the preceding instruction, such other acts purportedly committed by the defendant must be proved by a preponderance of the evidence. You must not consider such evidence for any purpose unless you are satisfied that the defendant committed such other acts. The prosecution has the burden of proving these facts by preponderance of the evidence. Preponderance of the evidence means that evidence is so evenly balanced that you are unable to find that the evidence on either side of an issue preponderates. You're finding that on that issue must be against the party who has the burden of proving it. You should consider all the evidence bearing upon every issue. The propriety of the judgment is not an issue for you to decide. You should not speculate as to whether the judgment was legally correct or not. Motive is not an element of the crime charged and need not be shown. However, you may consider motive or lack of motive as a circumstance in this case. Presence of motive may tend to establish guilt. Absence of motive may tend to establish innocence. You will therefore give its presence or absence, as the case may be, the weight to which you find it to be entitled. The flight of a person immediately after the commission of a crime or after she is accused of a crime is not sufficient in itself to establish her guilt, but which is a fact which, if proved, may be considered by you in light of all the other proved facts in deciding the question of her guilt or innocence. The weight to which such circumstance is entitled is a matter for the jury to determine. A confession is a statement made by a defendant, other than at her trial, in which she has acknowledged her guilt of the crimes for which she is on trial. In order to constitute a confession, such a statement must acknowledge participation in the crimes as well as the required criminal intent or state of mind. An admission is a statement made by a defendant, other than at her trial, which does not by itself acknowledge her guilt of the crimes for which she is on trial, but such statement tends to prove her guilt when considered with the rest of the evidence. You are the exclusive judges as to whether the defendant made a confession or an admission, and if so, which statement is true in whole or in part. If you should find that the defendant did not make the statement, you must reject it. If you find that it is true in whole or in part, you may consider that part which you find to be true. Evidence of an oral admission or oral confession of a defendant should be viewed with caution. Evidence has been received from which you may find that an oral statement of intent, plan, motive, or design was made by the defendant before the offenses for which she is charged were committed. It is your duty to decide whether such a statement was made by the defendant. The weight of evidence of an oral statement should be viewed with caution. No person may be convicted of a criminal offense unless there is some proof of each element of the crime independent of any confession or admission made by her outside of this trial. The element of the crime may be established by a confession or an admission. A person is qualified to testify as an expert if he or she has special skill, knowledge, experience, training, or education sufficient to qualify him or her as an expert on the subject to which his or her testimony relates. A duly qualified expert assists you in deciding such questions. You may consider the opinion as
Come on.
you may disregard any such opinion if you find it to be unreasonable. In determining the weight to be given to an opinion expressed by any witness who did not testify as an expert witness, your opportunity to perceive the matters upon which his
Dang it, StreamYard. Stop it.
Give an opinion that's based on that assumption. In permitting such a question, the court does not rule and does not necessarily find that all the assumed facts have been proved. It only determines that those assumed facts are within the probable or possible range of the evidence. It is for you, the jury, to find from all the evidence whether or not the facts assumed in a hypothetical question have been proved. If you should find that any assumption in such a question has not been proved, you are to determine the effect of that failure of proof on the value and weight of the expert opinion that's based on those assumed facts. In resolving any conflict that may exist in the testimony of expert witnesses, you should weigh the opinion of one expert against the other. In doing this, you should consider the relative qualifications and credibility of the expert witnesses, as well as the reasons for each opinion and the facts or other matters upon which it was based. A defendant in a criminal trial is presumed to be innocent until the contrary is proved, and in the case of a reasonable doubt whether her guilt is satisfactorily shown, she is entitled to a verdict of not guilty. The presumption is upon the people proving her guilty beyond reasonable doubt. It is not possible doubt because everything in affairs and depending upon moral evidence is open. That state of the case, which after an entire comparison and consideration of all the evidence, leaves the minds of the jurors in that condition that they cannot say they feel an abiding conviction to a moral certainty of the truth of the charge. In each of the crimes and allegations charged in counts 1 of the information, namely murder and personal use of a firearm, there must exist a union or joint operation of act or conduct and a certain specific intent in the mind of the perpetrator. Unless such specific intent exists, the crime or allegation to which it relates is not committed. The specific intent required is included in the definitions of the crimes and allegations charged. In the crimes charged in counts 1 and 2 of the information, namely murder, there must exist a certain mental state in the mind of the perpetrator. Unless such mental state exists, the crime to which it relates is not committed. The mental state required is included in the definition of the crimes charged. A mental disease or disorder of the defendant. You may consider such evidence solely for the purpose of determining whether or not the defendant actually formed the mental states which are elements of the crimes charged in counts 1 and 2, to wit, premeditation, deliberation, and malice aforethought. Homicide is the killing of one human being by another, either lawfully or unlawfully. Homicide includes murder and manslaughter, which are lawful, and the acts of which are unlawful, and the acts of excusable and justifiable homicides, which are lawful. The defendant is accused in counts 1 and 2 of the information of having committed the crime of murder in violation of Penal Code Section 187. Every person who unlawfully kills a human being with malice aforethought is guilty of the crime of murder in violation of Section 187 of the Penal Code. In order to prove such a crime, each of the following elements must be proved. A human being was killed, the killing was unlawful, and the killing was done with malice aforethought. A killing is unlawful if it was neither justifiable nor excusable. Malice may be either expressed or implied. Malice is expressed
Turn the camera back on.
when there is manifested an intention unlawfully to kill a human being. Intentional act, the natural consequences of the act are dangerous to human life, and the act was deliberately performed with knowledge of the danger to and with conscious disregard for human life. When it is shown that a killing resulted from the doing of an intentional act with express or implied malice, no other mental state need be shown to establish the mental state of malice aforethought. The mental state constituting malice aforethought does not necessarily require any ill will or hatred of the person killed. The word aforethought does not imply deliberation or a lapse of considerable time. It only means that the required mental state must precede rather than follow the act. All murder which is perpetrated by any kind of willful, deliberate, and premeditated killing with express malice aforethought is murder of the first degree. The word willful as used in this instruction means intentional. The word deliberate means formed or arrived at or determined as a result of careful thought and weighing of considerations for and against the proposed course of action. The word premeditated means considered beforehand. If you find that the killing was preceded and accompanied by a clear, deliberate intent on the part of the defendant to kill, which was the result of deliberation and premeditation, so that it must have been formed upon pre-existing reflection, and not under a sudden heat of passion or other condition precluding the idea of deliberation, it is murder of the first degree. The law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. The true test is not the duration of time, but rather the extent of the reflection. It is not necessary to prove the defendant maturely and meaningfully reflected upon the gravity of her act. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it included an intent to kill, is not such deliberation and premeditation as will fix the unlawful killing as murder of the first degree. To constitute a deliberate and premeditated killing, the slayer must weigh and consider the question of killing and the reasons for and against such a choice, and having in mind the consequences, she decides to and does kill. Murder in the second degree is the unlawful killing of a human being with malice aforethought when there is manifested an intention unlawfully to kill a human being, but the evidence is insufficient to establish deliberation and premeditation. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the crime charged, you may nevertheless the defendant is guilty of such lesser crime. The crime of voluntary manslaughter to that charge counts 1 and 2. The crime of involuntary manslaughter to that crime, to the crimes charged in counts 1 and 2. Thus you are to determine whether the defendant is guilty or not guilty of the crime or of any of the lesser crimes. In doing so, you have discretion to choose the order in which you evaluate each crime and consider the evidence pertaining to it. You may find it productive to consider and reach tentative conclusions on all the charges and lesser crimes before reaching any final verdicts. However, the court cannot accept a guilty verdict on a lesser crime unless you have unanimously found the defendant not guilty of the charged crime. The crime of manslaughter is the unlawful killing of a human being without malice aforethought. It is not divided into degrees, but it is of two kinds, namely voluntary manslaughter and involuntary manslaughter. Every person who unlawfully kills another human being without malice aforethought, but with an intent to kill, is guilty of voluntary manslaughter in violation of Section 192A of the Penal Code. There is no malice aforethought if the killing occurred upon a sudden or heat of passion. In order to prove such crime, each of the following elements must be proved. A human being was killed, the killing was unlawful, and the killing was done with the intent to kill. To reduce an intentional felonious homicide from the offense of murder, the provocation must be of such character and degree as naturally would excite and arouse such passion of the assailant, and the assailant must act under the influence of that sudden quarrel or heat of passion. Provocation can only serve to reduce murder to manslaughter when the victim actually initiated the provocation. The heat of passion, which will reduce a homicide to manslaughter, must be such a passion as naturally would be aroused in the mind of an ordinarily reasonable person in the same circumstances. A defendant is not permitted to set up her own standard of conduct and to justify or excuse herself because her passions were aroused unless the circumstances in which the defendant was placed and the facts confronted, which has also aroused the passion the ordinary person faced with the same situation. Legally adequate provocation may occur in a short or over a considerable period of time. The reason of the accused was so, Let's start over. The question to be answered is whether or not at the time of the killing, the reason of the accused was obscured or disturbed by passion to such an extent as would cause the ordinary reasonable person of average disposition to act rashly and without deliberation and reflection, or from such passion rather than from judgment. If there was provocation, That's right. Sore throat. Let me start with that last part again, ladies and gentlemen. I apologize. I'm getting a few weeks ago. The question to be answered not the verdict was obscured or disturbed by passion to such an extent as would cause the ordinary reasonable person of average disposition to act rashly and without deliberation and reflection, and from such passion rather than from judgment. If there was provocation, whether of short or long duration, but of a nature not normally sufficient to arouse passion, or if sufficient time elapsed between the provocation and the fatal blow for passion to subside and reason to return, and if the unlawful killing of a human being followed such provocation and had all the elements of murder as I have defined it, the mere fact of slight or remote provocation will not reduce the manslaughter. To reduce a killing upon a sudden quarrel or heat of passion from murder to manslaughter, the killing must have occurred while the slayer was acting under the direct and immediate influence of such quarrel or heat of passion. The influence has ceased to obscure the mind of the accused. Time has elapsed for angry passion to end and for reason to control her conduct. It will no longer reduce an intentional killing to manslaughter. The question as to whether the cooling period has elapsed and reason has returned is not measured by the standard of the accused, but by the duration of the cooling period. But the duration of the cooling period is to take the average and ordinarily reasonable person to have and that person's reason to have returned. Revenge or jealousy, nor a violent, intense, high-wrought or enthusiastic emotion, nor the emotion induced by and accompanying or following an intent to commit a felony, nor any or all of these emotional states in and of themselves constitute the heat of passion referred to in the law of manslaughter. Any or all of such emotions may be involved in a heat of passion that causes judgment to give way to impulse and rashness. Also, any one or more of them may exist in the mind of a person who acts deliberately and from choice, whether such choice is reasonable or unreasonable. Every person who unlawfully human being, forethought, and without intent to kill is guilty of voluntary manslaughter in violation of Section 192B. In order to prove such a crime, each of the following elements must be proved. A human being was killed, and the killing was unlawful. A killing is unlawful within the meaning of this instruction during the commission of misdemeanor, which is inherently dangerous, namely the offenses of unlawful possession of a loaded firearm, Code Section 12031, or exhibiting a firearm in a threatening manner in violation of Penal Code. The distinction between murder and manslaughter is that murder requires malice, while manslaughter does not. When the act causing death, though unlawful, is done in the heat of passion or is excited by a sudden quarrel such as amounts to adequate provocation, the offense is manslaughter. In such a case, even if an intent to kill exists, the law is that malice, which is an essential element of murder, is absent. To establish that a killing is murder and not manslaughter, the burden is on the people to prove beyond a reasonable doubt each of the elements of murder and the act which caused the death, and that the act which caused the death was not done in the heat of passion or upon a sudden quarrel. If a person causes another's death while committing a felony inherently dangerous to human life, the crime is murder. If a person causes another's death while committing a misdemeanor inherently dangerous to human life, the crime is manslaughter. Murder is classified into 2 degrees, and if you should find the defendant find the murder to be of the first, or it's beyond a reasonable doubt that the crime of murder has been committed by the defendant, but you have a reasonable doubt whether, if you are convinced beyond a reasonable doubt that the crime of murder has been committed by the defendant, but you have a reasonable doubt as to whether such murder was of the first or the second degree, you must give the defendant the benefit of the doubt and return a verdict fixing the murder as of the second degree. If you are satisfied beyond a reasonable doubt that the killing was unlawful, but you have a reasonable doubt whether the crime is murder or manslaughter, you must give the defendant the benefit of such doubt and find it to be manslaughter rather than murder. When the evidence shows the existence of provocation that played a part in inducing the unlawful killing of a human being but also shows that such provocation was not such as to reduce the homicide to manslaughter, and you find that the killing was murder, you may consider the evidence of provocation for as bearing as it may have on the question of whether murder was of the first or the second degree. Before you may return a verdict in this case, you must agree unanimously not only as to whether the defendant is guilty or not guilty, but also if you should find her guilty of an unlawful killing, you must agree unanimously as to whether she is guilty of murder of the first degree, murder of the second degree, or voluntary or involuntary manslaughter.
You guys are making me hungry.
If you find the defendant in this case guilty of murder of the first degree, you must then determine if the following special circumstance is true or not true: that there was a finding of guilt on a second count of murder in the first or second degree in this proceeding. The people have the burden of proving the truth of a special circumstance. If you have a reasonable doubt as to whether the special circumstance is true, you must find it to be not true. In order to find a special circumstance alleged in this case to be true or untrue, you must unanimously agree. You will state your special finding as to whether the special circumstance is or is not true on the form that will be provided. To find the special circumstance referred to in these instructions, multiple murder convictions, is true, it must be proved that the defendant has in this case been convicted of at least one crime of murder in the first degree and one or more crimes of murder in the first or second degree. The defendant personally used a firearm during the commission of the crimes charged. If you find the defendant guilty of one or more of the crimes charged or a lesser and included felony offense, you must determine whether the defendant personally used a firearm in the commission of such felonies. The word firearm includes a pistol or revolver. The firearm need not be operable. The term used a firearm, as used in this instruction, means to display a firearm in a menacing manner, intentionally to fire it, or intentionally to strike or hit a human being with it. The people have the burden of proving the truth of this allegation. If you have a reasonable doubt that it is true, you must find it to be not true. You will include a special finding on that question in your verdict using a form that will be supplied for that purpose. I have not intended by anything that I have said or done, or any questions I may have asked, or by any ruling I may have made, to intimate or suggest what you should find to be the facts, or that I believe or disbelieve any witness. If anything I have done or said has seemed to so indicate, you should disregard it and form your own conclusions. The purpose of the court's instructions is to provide you with the applicable law so that you may arrive at a just and lawful verdict. Whether some instructions apply will depend on what you find to be the facts. Disregard not an opinion as to the facts. The people and the defendant are entitled to the Each of you must consider the evidence for the purpose of reaching a verdict if you can do so. Each of you must decide the case for yourself, but you should do so only after discussing the evidence and the instructions with the other jurors. Do not hesitate to change an opinion if you are convinced it is wrong. However, do not decide any question in any particular way because a majority of the jurors or any of them favor such a decision. Do not decide any issue in this case by chance, such as the drawing of lots or any other chance determination. The attitude and conduct of jurors at all times are very important. It is rarely helpful for a juror at the beginning of deliberations to express an emphatic opinion on the case or to announce a determination to stand for a certain verdict. When one does that at the outset, a sense of pride may be aroused, and one may hesitate to change a position even if shown that it is wrong. Remember that you are not partisans or advocates in this matter, you are judges. In your deliberations, do not discuss or consider the subject of penalty or punishment. That subject must not in any way affect your verdict. The instructions which I am now giving to you will be made available in written form for your deliberations. They must not be defaced in any way. You will find that the instructions may be typed, printed, or handwritten. Portions may have been added or deleted. You must disregard any deleted part of an instruction and not speculate as to what it was or as to the reason for its deletion. You are not to be concerned with the reasons for any modification. Every part of the text of an instruction, whether typed, printed, or handwritten, is of equal importance. You are to be governed only by the instruction and its final wording. Do not disclose to anyone outside the jury, not even to me or any member of my staff, either orally or in writing, how you are divided numerically in your balloting as to the guilt or innocence of the defendant as to any crime charged or any finding required until I specifically direct you to do otherwise. You have been given notebooks and pencils. Leave them in your seat, on your seat in the jury room when you leave each day and at each recess. Notes are only an aid to memory and should not take precedent over your independent recollection. A juror who does not take notes should rely on his or her independent recollection of the evidence and not be influenced by the fact that other jurors took notes. Notes are for the note taker's own personal use in refreshing his or her recollection of the evidence. These various possible verdicts are set forth in the forms of verdict which you will receive. Only one of the possible verdicts may be returned by you as to any particular count. The corresponding form is the only verdict form to be signed as to that count. All other forms as to that count are to be left unsigned. You shall now retire and select one of your members to act as foreperson or presiding juror. He or she will preside over your deliberations. In order to reach verdicts, all 12 jurors must agree to the decision and to any finding that you have been instructed to include in your verdict. As soon as all of you have agreed upon a verdict, so that them dated and signed by your foreperson or presiding juror, and then return with them to this courtroom. Return any unsigned verdict forms. You will be permitted to separate at the noon and evening recesses. During your absence, the jury room will be locked. You are to return at 9 a.m. on the next succeeding court date. During your periods of recess, you must not discuss with anyone any subject connected with this trial, and you must not deliberate further upon the case until all 12 of you are together and reassembled in the jury room. At such time, you'll notify the clerk or the bailiff that your jury is reassembled, and then continue your deliberations. Very self-explanatory, so I don't think there's any need to go over them. There's a separate set of forms for each count as to each victim, Mr. Broderick and Mrs. Broderick. There are blanks on the form where you would fill in guilty or not guilty and did or did not with regard to the use of the weapon. There's a separate form for first-degree murder, second-degree murder, voluntary manslaughter, and involuntary manslaughter. I don't think you'll have any questions, but if you do, we're of course here to answer them. With regard to questions, occasionally during the course of deliberations, jurors have questions that they want assistance of the court or counsel on. If that incident or occasion should arise, it's necessary that you communicate with me only in writing. Write out the question that you have or questions that you have that note signed by your foreperson or presiding juror, and the bailiff will show you how to contact him to give him the question. There may be a delay in answering the question, not because you've stumped me, but because the attorney's going to have other appearances, and I know I'll get sent another case. So I only tell you that so that if you're at a point in your deliberations where you could go on to some other area rather than just sit there and wait for the answer, it would be beneficial. If you're not to the point where you go on to another area and must have that answer, then of course you have no choice but to wait. I would think any question you sent should be answered within a half hour. Just depends on how fast I can gather the parties together. As far as when you want to take breaks during the day, I allow the jurors to set breaks at your convenience. The bailiff will show you how to contact him so that he'll let you out for your breaks. I'll have some comments to make to the auditors. Just wait behind Mr. Shealy and Mr. Schmidt when the others leave. You swear the bailiff, please.
You do solemnly swear that you will keep your spirit together as in quiet and convenient place, and you will permit no person to sleep with them or communicate them, nor you speak with them yourself unless upon order of the court, or to ask them if they have agreed upon a verdict, and you will return them into court when they have so agreed or so ordered, so help you God. Yes,
Okay, now I'm going to find out how long they took, and then we're going to wait the same amount of time it took them. You guys want to wait? She did.
See, come to order, this court is now in session.
Versus Elizabeth Broderick, court finds. All members of the jury present. Two of the appellants are present. Mr. Schmidt waived his right to be present for these proceedings. All counsel are present. Mrs. Broderick is present. Mr. McAllister, I understand the jury has reached a verdict.
Yes, that's correct.
Would you give the forms to my bailiff, please?
Wonder if she's gonna do a Donald Adelson. Oh my God, no!
Clerk, can you read the verdicts?
In the Superior Court of the State of California and for the County of San Diego, the people of the State of California plaintiff versus Elisabeth Ann Broderick, defendant, Department 28, case number CR 112048, DA number B 685-888, verdict. We, the jury, in the above entitled cause, find the defendant, Elisabeth Ann Broderick, guilty of the crime of in violation of Pen 187 a felony as charged in count 1 of the information, and fix the degree thereof as murder in the second degree. Victim, Daniel Broderick. And we further find that in the commission of the above offense, the said defendant did personally use a firearm within the meaning of Penal Code Section 12022.5 dated December the 10th, 1991. Presiding juror, George McAllister. In the Superior Court of the State of California, and for the County of San Diego, people born in plaintiff versus Elisabeth Ann Broderick, defendant, Department 28, case number CR 112048, DA number B68588, verdict. We, the jury, in the above entitled cause, find the defendant, Elisabeth Ann Broderick, guilty of the crime of murder in violation of Penal Code Section 187 a felony as charged in count 2 of the information, and fix the degree thereof as murder in the second degree. Victim, Linda Broderick. And we further find that in the commission of the above offense, the said defendant did personally use a firearm within the Penal Code Section 12022.5 a. December 10th, 1991, presiding juror, George McAllister. The jury, were these
Court could poll them as to both counts together.
All right. Clerk, poll them as to both counts. Yes, one polling as to both counts. Let's record the verdicts. Waiver is recorded.
Yes.
Yes, sir.
Ladies and gentlemen, at this time I want to thank you for your service as jurors on this case. Service as a juror always interrupts everybody's daily routine. When
No, we
you
told the jury that.
serve on a case that's the length of this one, it calls upon you to make substantial sacrifices and adjustments in your daily schedules. So on behalf of the lawyer, myself, and importantly the others of this community, I sincerely thank each and every one of you for the time you've devoted to this case. You probably think I watch the ceiling lights a lot and don't pay attention to what was going on, but I did notice that you folks took a lot of notes. Some of you I know were on your second notebook full of notes. So I am aware of the fact that you were very attentive, and I sincerely thank you for your service in this matter. I particularly want to thank the alternates, Mr. Sheely and Mrs. Scott, and Mr. Schmidt in his absence. You probably have the hardest job of any of them because you don't get to state your opinion. You've got to listen to everything and pay attention, as I know you did, and you don't get to vote. So I know you've had a tough job. I appreciate the fact that you were willing to serve as alternates and that you did, in fact, pay as much attention as I know you did. I thank you, Expert Special, for your willingness to serve in this matter. At this time, ladies and gentlemen, you are, of course, released from your admonition not to discuss the case with anyone. You can discuss it with anyone that you want. However, it's important for you to know that you're under no obligation to discuss this matter with anybody. Attorneys or representatives of the attorneys or the press will most likely want to talk to you if you want to talk to them. I would only caution you that if you decide to talk to anyone about this case, that you say only what you will be in the presence of other jurors or in this courtroom under oath. I'd also remind you or ask you to consider your fellow jurors that they express their opinions in the jury room in confidence and in the confidentiality of that jury room. So if they want to express their feelings, I would request that you honor their personal opinions and let them decide whether or not they want to say how they felt. If you want to discuss how you felt, that of course is up to you. But I would ask you to consider the thoughtfulness and respect the views of your other jurors and let them decide whether or not they care to make a statement. Along those lines, I am sure that members of the media and the attorneys are going to want to talk to you. What I intend to do is in a few moments release you to go back to the jury room to pick up your personal belongings. I'll then make my courtroom available in approximately 15 minutes for members of the press and any of you that want to be interviewed or make a statement or whatever, or if you want to have a representative or whatever you want to do. Again, you're under no obligation to do anything, but I will make the courtroom available so that you won't be hopefully bothered at home or otherwise if you desire to make a statement. So my bailiff in about approximately 15 minutes would let you back into the courtroom where you can make a statement if you so desire. And again, you're under no obligation to do that. At this time, I would again thank you for your service as jurors in this matter, and if you follow my bailiff to the jury room to pick up your belongings.
Sentencing is next. We don't know yet, Nancy. Brian Walsh's trial is delayed by competency concerns. So I guess it's not going to start on the 20th. There's something on court TV at 12, but I don't think it's a hearing or anything. I think it's one of their news broadcast thingies, so I can't show it. Yeah, you don't get parole if you don't show remorse. And she's still blaming everything on Dan and Linda. So she's never going to get parole. Yeah, it's always Colin's fault. They always blame him.
The first order of business is the new trial motion filed by Mr. Early on his record should reflect that I've read and considered the moving papers filed by Mr. Early with this court on February 5th of this year. There has been no written response filed by the district attorney, I assume because of the timing of the filing of the motion. Do the people want to respond orally, or do you want time to file a written response?
Yeah, for the record, Your Honor, I can indicate that I personally did not receive this motion until yesterday morning. Obviously, with only a day before the sentence, I do not have time to file a written response, but I don't want to put the sentencing over. There are several people here from out of state and out of the country, in fact. So I do intend, if with the court's permission, to simply respond orally.
Agreeable with me. All right, Mr. Early. Proceed.
Your Honor, since I have presented papers with my position at this time, maybe it would seem to be appropriate if maybe just responding to whatever the district attorney's position is on the moving papers.
I think that's a great idea.
That's fine. Go ahead.
And I apologize if I'm a little bit unorganized, Your Honor, because of the lack of time to prepare for this. But first of all, I'd like to just comment about the statement of facts that's included in that motion for new trial. I should say it's a statement about allegations. This statement of alleged facts in this motion is, in my mind, just a patently propagandized account of the defendant's version here, for the obvious benefit of the press and probably ultimately for the benefit of the board. It can hardly be considered an accurate statement of the evidence that was actually presented at the time of the trial. I don't think it's worth going to point out the problems with the factual nature of that statement of facts, because I know this court heard the evidence. I know this court, which is the only person that matters at this point, has the ability to wade through that statement and determine what the relevant truth is. And ultimately, the parole board is definitely going to get the whole story. So with that objection in mind, the first claim made by the defense is the court erred in limiting Dr. Sonkin's testimony. I think it's important to point out, as the court well knows, that Dr. Sonkin was not precluded from testifying to begin with. He was simply limited to testifying about relevant evidence, which is obviously as it should be. Contrary to the defendant's claim, Dr. Sonkin was allowed to testify to the basis of his opinion. He was allowed to testify in its entirety about his interview with the defendant. He was allowed to testify about his opinion, and that his opinion was based on anything that he considered, the reports, the interviews that he considered. The only limitation that the court placed on Dr. Sonkin was that he could not testify to specific hearsay that was otherwise inadmissible. And that's because that's the law. The people cited the case to the court during the trial, People versus Coleman, which is the California Supreme Court case, that holds that that's the law. Obviously, it was a correct ruling by the court. It was proper for the court testimony to his opinion regarding emotional abuse, for one very important reason, and that is because there was no evidence to support anything else. There was no evidence, none, zip, zero, about any sexual abuse committed on the defendant. By her own admission, there was no evidence about any physical abuse post-separation for the 4.5 years prior to these murders. There was, in fact, no evidence of any actual abuse during the course of just by omission, they testified that Dan never intentionally struck her. Clearly, the court can issue 52 grounds to limit such testimony. In addition, the offer of proof about Dr. Sonkin's testimony included nothing about him testifying regarding the defendant's actual mental condition at the time of these homicides. The defense claimed that his testimony was relevant to show her state of mind, quote, during the marriage and during the separation. Her state of mind during those time periods was not an issue. The issue was not what caused this defendant to ultimately decide to kill Dan and Linda Broderick. The issue was, what was her actual state of mind, the killing? She testified about her state of mind. She testified that it was one of contemplating suicide because she was excited over not custody of the boys and all that happening during that fall leading up to that night or that morning. The defense themselves claim that over the summer, for a long period before that time, that there was no problem with the defendant emotionally, that she was doing much better, the marriage was over. Whether Dr. Sonkin believes, and by the way, I should point out that Dr. Sonkin, who is not even a licensed psychologist and who has a degree from a mail-order college, his opinion was very strongly disputed by several prosecution witnesses who were not ultimately able to testify because he didn't testify. But it was their opinion that the defendant didn't even come close to fitting the criteria for suffering from battered women syndrome. Whether Dr. Sonkin himself believed that she'd in some way been abused during the marriage years before was totally irrelevant. He also, and I know the court recalls this, he specifically said that he would not be testifying about any emotional abuse caused allegedly by way of the divorce process. He had no opinion regarding that. His opinion only related to her testimony, or her treatment, during the marriage. Our position, obviously, at the time was that his testimony was entirely irrelevant. He should not have been allowed to testify. The court, I believe, actually gave the defendant more than she was entitled to by law. Dr. Sonkin was allowed to testify regarding his opinion that she had suffered emotional abuse during the marriage, the basis of that opinion, and what the effects of it were. Elisabeth Broderick was allowed to testify and did testify as to what allegedly done to her to constitute. There is no error by the court's ruling. One last point with respect to Dr. Sonkin. His testimony, if relevant at all, even by defense's own concession, was relevant on the issue of premeditation and deliberation only. It was not admissible for consideration for heat of passion, and the court would have given us an instruction to that effect. Given the jury's verdict, this issue is moot. The jury convicted the defendant of second-degree murder. They could not have considered this evidence to reduce that murder to voluntary manslaughter. The issue is moot. The second basic claim by the defense in their motion is this all-encompassing that regarding, and they said papers that there was no limit on prosecution in presenting state-of-mind evidence regarding the victims. Well, maybe I was involved in a different trial, because that's ridiculous. There are probably 50 witnesses out there that could have related Dan Broderick's feelings about this marriage and what he was going through in this marriage and in this divorce, about his feelings about the defendant's emotional rejection of him, about her demands, about her temper tantrums. To put some of this in perspective for the jury, we had his entire deposition testimony that explained and disputed all of her claims of his alleged money. We didn't get to put that in perspective. We had his entire divorce trial testimony, which was extensive. It covered several days, that gave an entirely different side of the picture that was being portrayed by the defendant. A very enlightening different side, and we weren't allowed to do that because his state of mind regarding his feelings of the marriage, the divorce, being the victim of constant harassment by the defendant was deemed not relevant. I can also recall specifically the court sustained several hearsay objections during the testimony of Kathy Cafaro, which is what the defense now objects to. We were not allowed to present any of the numerous conversations that Dan Broderick had with Kathy Cafaro, his concerns for the children and what the defendant was doing to them, regarding his despair over not knowing what to do about the situation, regarding his reasons for not filing the contempt actions, regarding what had been related to boys about the defendant's threats and bringing the gun, and none of that came in. We were not allowed, through Dr. Sparta, to have him testify about any of the conversations over a span of 4 years that he had with Dan and Linda Broderick regarding their concerns for the boys, to explain why they had a concern about giving the defendant custody of those children. We were not allowed to introduce Dr. Sparta's opinion based on dealing with this family for 4 years, that Dan Broderick was not mistreating these children, not even close, that it was Elisabeth Broderick who was so emotionally abusive to them that he reported her to Child Protective Services, something that he's maybe done once or twice in his entire career. We were not allowed to present any testimony from several witnesses who had conversations with Linda very shortly before these murders about her fear the defendant was getting ready to do something, about the things that had been moved in the house and she was fearful of that, about the fact that she'd been confronted by the defendant in the house only a short time before these murders, about the fact that she was terrified. There were significant limits placed on the people regarding the victim's state of mind. What the defendant does here in this motion is basically just simply re-argue the arguments that were made at trial. With respect to the purported testimony of several witnesses, several last-minute witnesses, and the court did not err in excluding any of these, and I want to comment just briefly on each of them. With respect to Paul Taylor, even if what the defense says he says is true, and from what we know about his character and background, I submit that there's substantial reason to doubt his credibility. The fact is that it's completely irrelevant because it could have no effect on the defendant's state of mind. She knew nothing of it. It was something that was alleged to have occurred, if it did occur, 6 to 7 years prior to these murders. And consistently, also, Ms. Paul said in his statement, which was that Dan solicited anyone's murder. He did not the issue of money, and that his last statement was, I would never do anything because it's illegal. What's the relevance of that for the defense? With respect to the statements made to Steve Griffin, those suitable properly. Three grounds. One is that the defense did not comply with the court's discovery order. The court obviously has the right to impose sanctions for that, as they did not with respect to Paul Taylor. Rather than promptly turning that information over to the people, defense counsel instead attempted to, by asking questions, to improperly get information before the jury. That was improper. And everyone knows that if the people had done a stunt like that, the court would have granted a mistrial like that. We had no recourse for that type of improper conduct. And the court could have ultimately kept any of that testimony out for sanctions, even though I know the court didn't make its ruling on that ground. It was not newly discovered evidence. None of this was Steve Griffin or Paul Taylor. It was evidence that the defense was attempting to produce by ambush. They don't follow the rules.
Oh, we got the ambush word again.
His statements are textbook hearsay, offered for its truth, with no ability to rebut because Linda Kolkena is dead, and they don't qualify under the state of mind exception. Linda's state of mind regarding whether or not these allegations made by the defendant are true, her state of mind is not relevant. There is no hearsay exception. The defense wants to say that there's some exception that says that, well, if it corroborates what someone else thinks is true, then it comes in. That's not the law. The declarant's then existing state of mind must be an issue, and it is not. With respect to the alleged statement that was made to Steve Griffin in May of 1989 regarding using the legal system, that's also misleading by the defense. The fact is that, at least according to our interview of Mr. Griffin, Linda did say that, yes, they were using the legal system against Elisabeth Broderick because that's all they could do. And yes, they were hoping that finally by doing that, she would stop her harassment and leave them alone. It's an oxymoron to say that by using the legal system, which is what somehow would be legal provocation for these murders, it's not relevant. The statement from this man from San Mateo, who we have never received discovery on and have not had an opportunity to interview, again, obvious hearsay, offered for its truth. A conversation alleged to have occurred sometime in 1983, 6 years before these murders. A conversation that the defendant acknowledges she knew nothing of. The witness apparently can't even positively identify Dan Broderick as the person who made the statements. In addition, what is claimed by those statements is being thought, but what actually occurred to make it relevant. And the fact is that even her own attorneys say, all of them say that it was the defendant who wouldn't settle and who caused the proceedings to drag on and on and on for her obvious motives. The fact is that Dan Broderick did not take her children from her. If that had been his plan, he would have done it, and he didn't. He left the children with her, and she intentionally gave them to him. There's no relevance to the defendant's state of mind on the morning of these killings from this evidence. The airlines. My recollection is this was never offered by the defense. I don't know where this comes from, that there was claiming that there was some error by the trial court not letting this evidence in. Maybe I'm wrong and the court can point it out to me. I don't recall the defense ever offering it. Even if they had, it is so incredibly not relevant that I don't even think it's worth responding to. It is patent character assassination. I mean, me a break. We might as well go back to Linda's junior high school records to find out whether she ever cheated on a math exam or ever came in late after curfew. Theory about bad language is ridiculous. And named witness, unnamed attorney, regarding conversations with Dan and Linda and their property, I've never heard of. We received no discovery of. As my recollection is, it was never offered during the course of the trial. There was never any request to put on any such evidence. And beyond that, it's hearsay. It was unknown to the defendant. And even looking at it from a matter of practical logic, even if it's true, the state of mind, which was apparently to keep this information secret, it has no. This court bent over backwards to give this defendant a fair trial and to allow the defense to put on their evidence. She got
StreamYard, I don't know what your problem is. I'm hardwired in. Stop doing that.
to tell her story. The jury got to hear it, and it was not just left to be viewed in a vacuum as the defense claims. They got to put on both Dr. Lusterman and Dr. DeFrancesca to put her conduct in context with her emotional or her psychological state. Nothing that the defense argues is new in this motion. Nothing about anything cited should cause this court to question its original rulings, and the motion should be denied.
As well, Mr. Early.
Your Honor, it appears to be that the attack shifted from not only Elisabeth Broderick but to the defense itself in late discovery. It's interesting that at the time that I asked for hearing and for these witnesses to be present so that they could testify as to the true state of the facts, not only did the district attorney object to that because they did not want the court to hear the truth of these statements, but the court would not even hear from the witnesses. The district attorney now alleges that they have had interviews and tries to get the court to make the decision on a different basis and set of facts than the court was given, where we've been provided no discovery as far as any interviews. The attorney was provided discovery of the trial. They came forth in October. They came forth after hearing from watching, as it happens to be, Court Network TV, seeing what the position of the district attorney is, seeing what the truth of the matter was and the information they had, and they came forward to the defense. The district attorney got that information within a week after we had an opportunity to investigate that information to find out if it was true. And now the district attorney comes forward and says that the information that we had and that we brought forward wasn't true after they did not want to have a hearing. Again, the district attorney feels that the best way to look at this motion is to attack Dr. Zonkin and to talk about necessarily where he went to school and to characterize a school that has a very good reputation as a mail-order school, which is nowhere near the truth in this matter. The problem with Dr. Zonkin's testimony is we sat here in court, we went through it line by line by line. We took 50 pages of trial transcript from the first trial and reduced it to 2 pages. Reduced it to 2 pages where Dr. Zonkin had to divide out testimony as to emotional abuse and say, how do you divide that from the physical and sexual abuse that had been going on for years? Sexual abuse. They ran a motion before trial that said, we don't want this evidence to come out. We think it's irrelevant. The court sustained that. They directed Mrs. Broderick not to talk about and not to testify about those items, and then they come in and they complain that since they objected to it and they kept it out, that it can't be true because we didn't present it. As far as saying that there's no foundation for physical abuse, Dr. Zonkin testified that physical abuse can be in fits of anger. There's no doubt that there was a number of witnesses about Mr. Broderick tearing doors off of garages, slamming things around, kicking the dogs, screaming at the children, pounding the walls, grabbing Mrs. Broderick, asking her if she wants to be next. And then they say that that is not physical abuse. Well, maybe to the district attorney. That is the kind of civilized behavior that we should have in marriages. But anyone else would say that that is a form of physical abuse. And to go through a marriage of 15 to 17 years of abuse that starts at the beginning and continues on, and to say to somebody that you have to try to separate the effects of one form of abuse without the other is an impossibility. And Dr. Zonkin said, you cannot do that as an expert. You cannot look and say that here are the effects, and I can tell you that this form of abuse or this act of abuse caused this effect. They're all interrelated. The problem that we had with presenting evidence is Mr. Zonkin was allowed to say that I based it on interviews, I based it on police reports.
No, the problem is that he remarried and moved out and lived in another house with his new wife. That's the problem. That's your problem, Early. If she had shot him when they were still married and he was physically abusing her, then you'd have a case of spousal abuse. But you don't have that. You have her whining because he wouldn't give her enough money. You've got greed and selfishness and entitlement. You don't have a spousal abuse case.
But was not allowed, and we went through line by line, to go into detail about what he based it on, what Elisabeth Broderick told him, what the interview said. It was interesting that when the district attorney had their doctor on the stand, that they went through asking lots of questions, even when I objected to him, about what did you read in the diary? What did this person tell you? What else did you, what other information did you have? And went into detail, at least at the information that they had about that time, about Elisabeth Broderick. The truth of the matter is that Dr. Zonkin's testimony was left for him to get on the stand and say, I have an opinion that she was suffering from emotional abuse. I can't tell you what I based that on. I can't tell you what else it was involved on. And I can't really tell you about what the effect of that is. He was not allowed to give any information as to corroborating evidence. And it's right as far as Coleman saying that the court has the discretion to decide whether a doctor can rely on hearsay. It doesn't say that all hearsay cannot be relied upon by the doctor, but the court has to look at the hearsay, the reliability of the hearsay, and the court then has to make a determination, is that something that someone can normally rely upon? Does it have any area of truthfulness at all? So when we go into the conversations he had with family members, the ones he had with neighbors, when he goes in and the threats that Mr. Broderick made about neighbors, about saying things about him that weren't true when they spoke badly about Mr. Broderick, those things, yes, are hearsay because the witnesses aren't allowed to testify. But Coleman does not say, and none of the cases say, that you cannot rely upon him or that you cannot bring him in. The court has to use discretion. And I don't believe that it's complete discretion for the court to say that none of those will come in at all. I think the court has some duty to look to see what, how those issues, or at least which hearsay should be admissible, or would it.
Cognitive dissonance. That's why. She knew, but she just chose to ignore it. When they did the marriage encounter thing, and he was like, oh, well, let me get my own practice and make money, and then I'll be a better person. Then I'll be a better husband and a better father. No. Right then and there, I would have said, no. You're going to put me and the kids first, or I'm leaving. Because that's not a marriage. He wanted to marry her so bad. He chased her, and she kind of acted like she didn't really care. Either that or she was playing hard to get. I don't know which. And that's not how you do marriage. Yeah, you have to make money to support them, but he was making enough money to support them. He wanted to make a name for himself and make a lot of money, and that came first. And then he got all that, and then he had his midlife crisis, and he wanted to marry the young, pretty girl in the office. It was like the family was just part of the big picture of being successful. Like, he had the family and the connections and the country club and the, you know, like, the family was part of the, I don't know what word. I can't think of the word. Yeah. Yeah, she didn't want it to end. Like, maybe, Marty. Maybe. But it was like an illusion. Like the American dream illusion. Like he had the trophy family. Like, you know what I mean? And then he wasn't happy. And so then he got Linda and he was happy. And it pissed off Betty.
Instances should be admissible and which ones that a doctor would use normally in his opinion. I don't believe the issue is moot. There is a law in California that when you are talking about a battered woman syndrome, when you're talking about the elements around it, that is admissible without limitation. It doesn't say in the law that it's admissible only to premeditation and deliberation. What the case law says is that psychiatric testimony, yes, has been limited as to what it can be considered for both by the court and a jury, unless there is a statute, and there has been a statute by the legislature. And this Supreme Court, with a statute, does not have the ability to say that they will not follow that law. I believe that there was obviously, Dr. Zonkin's testimony was important at the first trial, and I believe that it was part of the testimony that should have been admitted in its full in the second trial. The district attorney goes through, and it's interesting that the district attorney complains about this late date of the witnesses that they wish to call, but they never attempted to call all those witnesses. They never made an offer of proof to the court. We never had a hearing on that. The very beginning of the trial, I told the court, I think this case they should let all hearsay in. They should let everyone take the stand and let the jury hear from every witness that has something to say on this case. Let them come forward. They could have brought in as much character testimony as they wanted to, but the district attorney knew that by bringing what they called the character evidence in, they would be faced with the fact that there was lots of testimony out there. There was a lots of truth to rebut that.
Yep,
and the district attorney said they were limited. They weren't limited. They were limited by the fact that the defense had evidence that would have shown and would have balanced the picture that was being presented by the district attorney. The district attorney, interestingly, in their opening statement, brought in the fact of Linda Kolkena, where she worked, that she was a paralegal, that she left there to become a paralegal. She never introduced the evidence. Didn't introduce the evidence was because she was trying to bring it in before the jury, but she didn't want all of the evidence in. She didn't want that to be balanced. She wanted the jury to believe a particular set of facts that weren't there. She argues in this statement that she was not allowed to bring in a statement that Linda Kolkena said Elisabeth Broderick can't come in the house weeks before homicide and was very afraid of Broderick. Well, the true state of facts is it would have welcomed to bring that statement in because it was an allegation during this trial that Linda Kolkena had been spreading rumors about Elisabeth Broderick, that she was out to destroy her. And isn't it interesting that when they file a contempt order through their own law, and they bring up 2 phone calls from Elisabeth Broderick They don't put in the moving paper that Elisabeth Broderick 2 weeks early broke into their house in the middle of the night and confronted Linda Kolkena. Not only could have they called the police, and that would have been a crime, but it would have been the first statement they would have made in an order to the court to show contempt. There was a restraining order. If there was any truth to those statements, it would have been brought forward. The district didn't bring them into court because it was nothing but the history of the case. And now, at late day, when the district attorney tried to introduce, she could tell this balance because she didn't bring those things in. It was never offered to the court. The whole litany of items that she brought in and that she said that she would have liked to introduce, she never tried to introduce them. Stephen Griffin was denied under Prop 115. We got that information 1 week before we tried to present that evidence, and the district attorney said, and the same with Paul Taylor and Steve Smith, we gave it to them 2 days after we got the information. We're able to find out who he was and where he worked, and was he actually a deputy district attorney. And
I've never received any information about Steve Smith.
Your Honor, we had a hearing. I made the offer, and they asked for discovery, and I gave them the notes. At that time, we had a hearing in court. This district attorney has never come into this court and not demanded discovery. And it's hard for me to believe that when we had a hearing and made an offer of proof that the district attorney is saying, I just never asked to see a statement.
No, I'm not saying that. I'm saying I never got a statement. I never got any discovery.
Whether she got discovery, there was an offer of proof made to the court. The court made a ruling based on the offer of proof. Court ruling on the offer of proof. Was still, the district attorney makes allegations that we were laying in the weeds. We were hiding. This is something that we had found out that we came to the court 2 days after we got it, when we were able to find it. The lawyer that Linda Kolkena and Mr. Broderick went, we came the next day to the court. Paul Taylor, we came as soon as we checked those items out. And the interesting thing is when the court ruled that the district attorney, the reason that they were not going to allow the statements in from Steve Griffin was because the district attorney on cross-examination asked Elisabeth Broderick, why would Linda Kolkena want to mail these items to you? She want to mail wrinkle cream commercials. Why would she want to mail a tablet out to you with the statement, eat your heart out, bitch? When we saw the other statements from Linda Kolkena that had the same yellow tab, that derogatory towards Elisabeth Broderick, that we knew came from her. But the interesting thing is the district attorney said, you knew I was going to ask the question. Wasn't concerned that she was asking a question that had no truth to it, and maybe the jury should know the other side. But said, you should have known I should ask the question. At the first trial, she never asked that question of Elisabeth Broderick. Never said to Elisabeth Broderick, how would you know? Why would Linda Kolkena do that? She did argue her argument, but she never asked that question. So the ruling that the court made that somehow I should have known that she was going to ask a question that didn't represent the true state of facts and is an improper question to begin with of Elisabeth Broderick, why calling for speculation, the court ruled that that information doesn't come in. And there were other remedies available. The court could have instructed the jury that this item was supposed to be turned over and wasn't turned over for 5 days, and somehow the district attorney asked the question that wasn't there. There's a lot of other remedies that the court needs to go through. Those statements were not gone through. When you look at the cases that I cited in my moving papers, it's clear, and there's a lot of case law that talks about victims who are called victims in instances like this, in self-defense cases. It's clear that their state of mind is at issue. Did they act in conformity with? And that's 1250. And 1250 does not say self-defense cases. It said if the person or the victim's conduct is in issue, there is an exception to the hearsay rule if they make a statement that shows their present state of mind, and if it's relevant to the issues of the case. Our defense in this case was provocation. In the Coleman case, in the Hamilton case, and other cases, provocation has, when they've given examples of what a person's state of mind is that you can prove under this exception. One of the things that is mentioned is provocation. And a district attorney misses the point when the district attorney says Elisabeth Broderick needs to know what these statements are. That's not what 1250 says. 1250 says that if it say it shows an existing state, then that is, and it said in my moving papers, is that Elisabeth Broderick was married to Dan Broderick for 15 years. He told her how he practiced law, and she testified to that. He told her how he liked to destroy other people through his law practice, how he either liked to humiliate him or attack him, serve him in a church. He liked to send him nasty grams. He thought that was effective. And what she talked about is, knowing that, exactly what she felt Mr. Broderick was doing to her. The reason that I mention that in my moving papers is it clearly shows how important this is to show his then existing state of mind. It wasn't just Elisabeth Broderick saying this. This is Mr. Broderick saying to it. And the district attorney says that maybe this deputy district attorney from San Mateo County is a flaky witness. Maybe they shouldn't be listened to. Maybe they shouldn't be here. Maybe it's unreliable. I don't know if that's their position. The thing that's interesting, in 1983, why would Mr. Broderick say that he was going to drag her through the system, he was going to make it go on, that he was going to take her children away? He talked about a gun then. He talked about making it look like suicide. And when you look at that, that's exactly, at that point in time, what happened. Later on, I mean, that's exactly the plan that was followed. And it shows his then existing state of mind, what he was going to do. Mr. Broderick was a very intelligent man. He wasn't going to go into the court and say orders, or I want to do this because this is what I plan to do.
Marty.
But he didn't know at that point in time that those statements at some point in time would surface during this period of time. I think that those statements all go to then existing state of mind. The court, and if the court will recall, a security guard testified at the trial. The security guard said that he guarded the wedding. What the court allowed in is why he did that. And that was a conversation with Mr. Broderick, and it was because Mr. Broderick had a fear of Elisabeth Broderick. And he had a fear of what she was going to do and how she's going to disrupt the wedding. The court just said that's foundation, but it's hearsay. And what that foundation does is it shows his then present state of mind to explain his course of conduct. When Kathleen Cafaro got on the stand to testify, she testified in part as to some of the conversations she had with Mr. Broderick as to why she was filing certain pieces of paper. Those all came in, as the court called it, foundation, but when you look at it, the only reason they could come in is to show the state of mind. They're clearly hearsay, and the foundation is to show why he acted in a certain way. And I believe that the jury, getting that only representation, deserved to have the other side. Whether they believed one side or the other, whether the district attorney had 20 other witnesses that were friends of Dan Broderick to say otherwise, I think that those witnesses should have been presented. Stephen Griffin, in the offer of proof, the district attorney again brings up what he would say hopefully now for the district attorney, even though they haven't provided discovery. But the offer of proof is that he had a conversation with Linda Kolkena, or Linda Broderick at that time, in May of '89. And the offer of proof was that they were still going through the divorce process, that they talked about the fact that it's not good to attack an ex-wife, it makes things bad. And she said that we were a law office, and it doesn't cost us anything, and if we keep dragging her through, she'll finally give up and go away. Again, we asked for a hearing on that. We were confident of what the witness will say. The district attorney also objected to that hearing and now wants the court to consider a different state of facts than was presented at the hearing. All I can ask the court is to consider the hearing that the court had, the offer of proof that was made to the court, because that's what the state of evidence is. And I think that when you look at the verdicts in these cases, in this case, I don't think the court can say that evidence was not important. That obviously the jury rejected premeditation and deliberation. I think we have to look at that from the verdict. And that testimony was not allowed in. And I believe that testimony would have had a profound effect upon this jury because it profoundly explains the situation as we have it. It casts a light that does not just put Elisabeth Broderick saying, this is what I believe, but it puts it that this is what I believe, and this is what Mr. Broderick said that he was going to do. I think that that when the court looks at all of the evidence, and I realize it's from hindsight, but when the court looks at it, looks at the verdict in this case, I think that the conclusion is there was error that the jury not be able, those tools, to be able to have, to decide whether to accept or reject the defense that was presented in this case. And for those reasons, I would ask the court to grant our motion for a new trial.
Thank you, Mr. Early. Ms. Wells, do you want to respond?
I'll submit it, Your Honor.
Well,
Nope.
as has been summarized by both counsel, there are really two basic bases that are being alleged for the new trial motion. The first was my restriction of the testimony of Dr. Sonkin. Dr. Sonkin testified at the first trial that in his opinion, Mrs. Broderick was the victim of sexual, physical, and psychological abuse. After listening to all the evidence of the first trial, I informed both counsel before this trial started that I was going to have a 402 hearing with regard to foundational facts as to sexual or physical abuse because I found them to be lacking in the first trial. We had that hearing. At the time, or at the conclusion of the hearing, I ruled that he could not testify as to sexual or physical abuse because I found there had been an inadequate showing of any foundational facts to support those opinions. In fact, with regard to physical abuse, the testimony at the trial was exactly the opposite. First, as pointed out by the district attorney, Mrs. Broderick herself testified that she was never intentionally struck by her husband. There were 3 incidents of physical contact that were mentioned at various phases of the trial. First had to do with a skiing incident where Mrs. Broderick apparently ran over the tip of the ski of Mr. Broderick, and he shoved her down. That was before the marriage and clearly wasn't relevant to anything that happened during or after the marriage. There was what Mrs. Broderick herself described as an accidental or unintentional striking of his elbow or upper arm or forearm that hit her in the eye and caused a black eye. She regarded that as an accident. That is the only incident that I recall being testified to that took place during the marriage itself. After the third incident that was directly related and took place immediately following the time when she ran her car through the front of the door of the house on Cypress Street. It was at a time when one of the daughters was standing between her mother and Mr. Broderick, and she was trying to strike him with keys that she had in her hand. He shoved her away. At best, or at worst, that's self-defense, and certainly, since it occurred after they were separated, certainly wouldn't be considered a battered women's syndrome, in my opinion. Another fact that we haven't mentioned is the fact that during the interview with Dr. Sonkin, the defendant told Dr. Sonkin that she did not consider herself to be a battered woman. I ruled, therefore, that the doctor could not give an opinion or render an opinion on a condition to which there were no foundational facts. It's my understanding that that is the law. I am comfortable with that ruling. I did not rule that he could not testify with regard to psychological abuse. I did not rule that evidence of psychological abuse could not be presented. I did not rule that evidence of a battered women's syndrome could not be presented. I would note, as has the district attorney, that Dr. Sonkin had no opinion as to what effect, if any, psychologically that the the dissolution proceedings had on the defendant. He had no opinion as basically from 1986 to the time of the homicides as to what effect the various filing of documents and appearances, etc., had on the defendant. His psychological opinion was based up until the time of their separation. After consulting with Mr. Early overnight, he decided not to testify and give that opinion. Mr. Early chose not to offer that opinion type evidence through any other mental health professional. This court did not exclude any relevant testimony by Dr. Sonkin. It was a tactical decision by the defense not to present that testimony. Therefore, the motion for new trial based on restriction of Dr. Sonkin's testimony is denied. That takes us to the second area of the motion for new trial. There are really 5 different incidents defense alleges error from the standpoint of the court restricting testimony as to one or the other of the victim's state of mind. Start first with the Paul Taylor incident. The record is absolutely clear that the defendant had no knowledge of that incident until sometime in November of 1991. Therefore, by no stretch of the imagination could it possibly have affected her state of mind 2 years before at the time of the homicides in November of 1989. Secondly, this was not a self-defense case. Clearly, the defendant was not in any imminent danger of death or great bodily injury at the hand of either victim at the time of the homicides. Since it was not a self-defense case, the reputation of the victim, Dan Broderick, for violence in the community would clearly not be admissible, and so the evidence was clearly not admissible under that theory. I would also note that there was never any evidence even offered by anybody that there was ever any attempt made on Mrs. Broderick's life by anyone at any time. With regard to the Stephen Griffin incident, he was asked to mail an envelope allegedly by Ms. Kolkena in late 1986 or early 1987. First of all, Ms. Kolkena's state of mind was not an issue in my opinion. Secondly, that is excludable under 352, and that any probative value would have been purely speculative, as the offer of proof was that he had no idea what may or may not have been in that envelope. But even if the court were to speculate that there was a wrinkle cream ad in that envelope, and even if I was to stretch legal adequate provocation to include mailing an envelope with a wrinkle cream ad, the 3-year cooling off period between the time that was allegedly mailed and the time of the homicide clearly would not have been adequate provocation for any homicide in November of 1989. It also, in my opinion, is an appropriate sanction under 1054 of the Evidence Code. Since there was a discovery order in this case, it was not used in the first trial because the California Supreme Court had not ruled on the constitutionality of the discovery provisions of Proposition 115. But I clearly told both counsel prior to the start of the second trial, that since the the California Supreme Court in Izaga had ruled that the statute was constitutional, that it would be applied in this case. Therefore, the decision not to immediately turn over that information was in direct violation of my order, and I think is a proper sanction to exclude it on that basis. With regard to this Tahoe incident of Mr. Smith, again, the defendant herself was not aware of that, and again, it's my ruling that the victim's state of mind at that time was not an issue. But more importantly in this case, I believe, is the fact that the jurors did in fact hear what actually happened. They had the facts of actually what occurred, many as were over the objection, rather strenuous objection of the district attorney. I let the defense go back as far as 1976 and put in a marriage encounter statement that was written by Mr. Broderick. I let in all of the various filings and hearings that were held in the divorce proceeding, of which there were at least 6 different charts with a timeline, all over the strenuous objection of the district attorney. I allowed Mrs. Broderick wide latitude in testifying and stating exactly what happened to her and exactly how she felt about it. She testified for between direct and cross over a period of 5 days in this case. She had, in my opinion, a full and complete hearing. Although an outsider listening to the arguments of both counsel this morning would think that I kept out every piece of relevant evidence either one of them had to offer. That is not the case. This trial lasted, as those that followed it are aware, for several months. They both, in my opinion, had a full and complete opportunity to present what I found to be relevant evidence. Another basis, or another thing I would note, I should say, with regard to this particular incident, is that what is alleged to have happened to the current spouse through the court system. In my opinion, the record of this trial shows that not to be the evidence. In addition to what Ms. Wells has referred to as the testimony of several of her lawyers, and with all due respect to lawyers, I can discount what they said because I know Mrs. Broderick doesn't have much of a regard for lawyers. But if we discount what her lawyers said, we can look to what happened that would suggest strongly that he was not trying to drag her through the court system. We have the fact that a judge of the Superior Court got very upset with Mr. Broderick for arguing that he should not put Mrs. Broderick in jail for contempt. Certainly not, in my mind, consistent with someone trying to drag somebody through the court system. We have the undisputed testimony that with regard to the alleged improvements, landscaping on the Coral Reef House, that when Mrs. Broderick asked or asserted that in fact devalued the property, Mr. Broderick agreed that the value of those, that the cost of those landscaping items could be taken out of his half of the sale of the proceeds of the house, and that he would give her her half plus the alleged cost of devaluing the property. That, in my opinion, again, is an example of something that's not consistent with somebody trying to drag somebody through the system, but rather is more consistent with somebody trying to bring this thing to a logical and speedy conclusion. I also think the evidence was excludable under 352 because even if there is some relevancy or some remote probative value, that was clearly outweighed by a substantial probability that its omission would have created a substantial danger of confusing the jurors as to the issues and misleading them. The victim's intent, if it was his intent, as expressed after he had been drinking in a cocktail lounge in 1983, was clearly not the issue for this jury to decide. The defendant's state of mind in November of 1989, some 10 months after the final divorce judgment, was what the issue was in this case, in my opinion. Finally, again, this evidence, I believe, is excludable under 1054 as a sanction since the DA, even by their argument today, counsel concedes the DA consistently asked if he had any new information or new witnesses. He chose not to disclose it basically until after the cross-examination of the defendant was finished.
Your Honor, I'm going to have to object to that. For the court to make a finding, I turned that over the very next day. You're talking about Stephen Griffin. You're talking about Steve Smith now. I turned that over at Charles Smith. I turned that over the very next day. For the court to make a finding on that case that it's 1054 at this list, I think is inappropriate.
You made your record, Mr. Early. In my opinion, the whole purpose of Section of the Prop 115 and Section 1054 of the Evidence Code, the whole reason it was passed by the people of the state of California, the whole reason the California Supreme Court upheld it, was to make sure that both sides get a fair trial in a criminal case, just as both sides have had the opportunity to receive a fair trial in a civil case, because in civil law, both sides have had full and complete discovery pre-trial up until Prop 115. That had not been the case in a criminal matter. That takes us to the Delta Airline incident. There was never any request by me to rule on anything to do with Delta Airlines, period. I never saw any or heard any offer of proof as to anything to do with Delta Airlines. I first read of that incident in quite vivid details. I had not heard of it, nor had there been any request of me to rule on it prior to today.
Just give them boxing gloves,
Finally,
Judge,
the
and let them get out.
alleged error in excluding the testimony of the local attorney who would have testified had I allowed it that he was consulted by both the victims pre-separation with regard to the possibility of them hiding assets. Assuming that's what he would testify to, that evidence would be irrelevant to a divorce trial. It's clearly not relevant to a homicide trial. Again, I'd note for the record that the defendant had no knowledge of such a conversation taking place, therefore it clearly could not have been legally adequate provocation. And finally, I'd note for the record that Mr. Taylor, Mr. Griffin, and the local attorney all knew the parties at least from 1983 forward. None of them chose to come forward during the homicide investigation of 1989. None of them came forward during the first trial, which was substantially and significantly publicized in 1990. They don't come forward till late in the second trial. Over and above and beyond the relevancy issue, that raises a serious credibility question in this court's mind. Therefore, the motion for a new trial is denied. You waive arraignment for judgment and sentence?
Yes.
Any legal cause why judgment and sentence should not be pronounced?
No, Your Honor.
Record should reflect that I've read considered the probation department's report prepared for today's hearing. The record should further reflect that I have read and considered the statement, sentencing memorandum or statement mitigation with the attachments filed by Mr. Early on his client's behalf. The record should further reflect that I have read and considered the district attorney's statement of factors for denial of probation. The record should further reflect that I have read and considered the social document entitled Social History with its attachments filed by Mr. Early with this court yesterday. The record should further reflect that I have read and considered numerous letters from friends, relatives, and concerned citizens that were sent directly to the court and which have been filed as part of the court file in this case. Mr. Early.
Yeah, I believe I was in the court first.
All right. Yes.
I don't think that there could possibly be any disagreement that this case and the events of this case is tremendously tragic in lots of ways and to so many people. It is obviously an absolute tragedy to the family and friends of, for example, Linda Kolkena, to Linda's sister and to her brothers and to her father, her father particularly, who has lost his baby daughter and has to live for the rest of his life without her. It is an absolute tragedy to the family and friends of Dan Broderick, to his brothers and sisters who absolutely adored him, to his parents who now in their not too many years left of their life, they have to live with simply the pain of not having Dan with them anymore. It is an absolute tragedy to the 4 Broderick children who lost their father, who they loved, and who loved them, and who they deserved to have for their life. It's also a tragedy to the defendant's family, to the Bashalias, who have to live with this and what's happened. There can also be no disagreement that the cause of all of this pain to so many people is the conduct of Elisabeth Broderick. There is no way that this court, by its sentence, can make these people whole again. I know from experience that the pain of losing someone that you love to a violent and senseless death is something that never leaves you. It does get better with time, but it never goes away. And I also know that beyond that, the one thing that makes it truly intolerable to live with is the feeling that justice was never served for that loss. The only way that these people, these victims, can begin to heal by seeing that there's been some form of justice. I cannot fathom any possible sense of justice when the crimes are murder, when the crimes are taking the lives of 2 people, in any sentence other than one that punishes for both of those killings. To do anything other than that is to say to these families and to these friends that one of the victims' lives didn't matter. One of them was inconsequential. How are we going to say that? Dan's life didn't matter. It is also to say to not only this, if you're going to kill someone, you might as well go ahead and take out a couple extra people too. Because as long as you do it all at the same time, those killings are going to be free. Broderick has been convicted of intentionally shooting and killing without provocation 2 people who were in the most vulnerable position they could possibly have been in their own home, in their own bed, sound asleep. The concept of not punishing her for maliciously taking each of these lives, to me, is, and it certainly doesn't smack of justice. Defendant discusses in his sentencing statement the sentencing rules, particularly Rule 425, regarding of sentence. And as the court knows, those rules do not apply to indeterminate terms. But even if you wanted to use them as guidelines, the defendant's argument regarding consecutive sentences for separate acts of violence is flat out wrong. The argument is just simply wrong, and even the case that they cite, People v. Thurs, states what has long been the law, as long as I know, that a defendant can be punished for each crime of violence against a separate victim, even if the defendant entertains a single objective, which she obviously didn't hear. She wanted to kill both. And even if it occurred during a single course of conduct. Even, in fact, the case law is if she had shot one bullet and it had gone through two people. The law says that the court can appropriately give consecutive sentences. How can killing two people not be more egregious than killing one? The defendant also suggests that concurrent sentences should be imposed because this was simply a single period of aberrant behavior. Well, that simply ignores the facts. The defendant had been violently acting out on her anger against these victims for years. But what she really is all about underneath, and underneath, she is a very disturbed woman. One of the issues with respect to the defendant is her potential for future violence. The defendant argues that the circumstances leading to her committing these two acts of murder will never repeat. Therefore, we shouldn't worry about it. I very strongly, adamantly disagree with that. Obviously, the exact same circumstances are not going to repeat. But the circumstance of Elisabeth Broderick feeling that she has been wronged by someone is absolutely likely to repeat. In fact, it has repeated. I know the court is aware of the letter that Elisabeth Broderick only recently sent to Kathy Broderick. It was attached to Kathy Broderick's letter that was sent to the court. And I'd like to just read a small portion of that letter. She's writing this letter to her son, Danny. Why is Kathy Broderick being such a bitch about letting you kids be with me? I never thought she'd be such a jerk. She knows well how bastardly Broderick men could be. I would have expected her to have more sympathy. Too bad she's causing us all more trouble. It didn't have to be this way. February 4th is the next hearing on custody. I will be strongly opposed to her having anything further to do with our family. She is not in our family, I am. If she keeps me from communicating with you, she's gone. None of us need any more of this shit. Kathy Broderick, by the way, as the court I think knows, is the aunt of the Broderick children by marriage. And immediately after their father was brutally killed and their mother was placed into custody and they were essentially orphaned, Kathy Broderick had the compassion to come forward and take these children into her home and give them love and give them security, in particular, the two boys. She has 3 young children of her own to raise. For over 2 years, she's been taking care of these boys under very difficult circumstances. And what does she get for that? Not thanks. Not thanks for being there for them. She gets hate. Hate and anger and threats. Do we really want to take the chance of taking these threats lightly, like people took the threats that she made against Dan and Linda lightly? And maybe even more important about what's going on in this letter is what she is continuing to do to her children that she did all along. And this is something that frankly never ceases to amaze me. Danny, her son, is living in this environment, living with his Aunt Kathy. Does it occur to Elisabeth Broderick to tell Danny, to assure him that Kathy loves him, cares about him, to encourage him to love Kathy back, to foster a good relationship between them so that he can be happy and secure? No. What she does is spew hate at the expense of her children. No matter how you want to analyze this woman, whether you want to say she's evil or whether you want to say she's sick or she's psychologically troubled, the fact of the matter is that Elisabeth Broderick is one of the most supremely selfish persons that you can possibly, and the way she has treated her children epitomizes that. She used to treat her children. She thinks she's special. Her chick is amazing. She thinks she deserves treatment. The fact of the matter is, she is simply a textbook narcissist. She is a narcissist who is so absorbed in her own importance that she emotionally abuses her children, sacrifices them, that she kills because she's angry, that she acts out violently in the jail, including doing things such as smearing excrement on the walls because something didn't go the way she wanted. That's the essence of Elisabeth Broderick.
Yuck.
And she's never to blame. She's always the victim. Well, Elisabeth Broderick is not the victim here. If anything, she's the victim of her own inability to truly care about anyone other than herself. And that's not something that just suddenly appears in a woman when she's 38 years old. I think that it's time for everyone, including the press, to do what Elisabeth Broderick so richly deserves, and that is to ignore her. To her, that is a fate worse than imprisonment, because she so loves and so well plays the part of the martyr. Well, Elisabeth Broderick is not a martyr. She's a murderer. She's a convicted murderer. And it's time for her to be treated just like every other convicted murderer. And that's by imposing sentences for each of the murders that she committed. There are some people here in the court that would like to address the court, Your Honor. And I think it's appropriate to do that at this time before the defense speaks.
Certainly, go ahead.
First of all,
Hey.
Barry's back, Your Honor.
Go ahead. State your,
I'm sorry, go ahead.
state your name and spell your last name, please, ma'am.
My name is Margaret Kolkena Seats, Kolkena hyphen Seats, Seats.
Thank you, ma'am. Go ahead.
Thank you, Your Honor. And I think that the only pictures you've probably seen of Linda have been of her body, so I'd like to just put this up there. These past few weeks, as I tried to prepare for today, I had difficulty framing my thoughts. How can I possibly summarize the impact that Linda's murder has had on our family and on our friends who loved her? Earlier this week, I spoke with Carrie Wells, who reminded me that the only things you know about Linda are what came out in the trial, which is not complete. So what I would like to do is tell you about Linda and the kind of family we come from. Our parents grew up in a small town in Holland called Groningen. They both came from big Catholic families, and a large part of their childhood was spent under German occupation during World War II. After our father served a stint in the Dutch Army stationed in Indonesia, Mom and Dad met through Mom's older brother, who was a friend of Dad's. Our mother came to the United States with her family in 1954, and then traveled back to Holland 1.5 years later to marry our father. They were married by a justice of the peace in Holland, but did not share a cabin on the trip back to America, nor did they live together until they were married by a priest and in the eyes of God. 3 days after coming to Salt Lake City, which is where we all grew up, Daddy started working at Garrett Freight Lines on the loading dock. Often he would work a second and sometimes a third job to support our family, but he would remain at Garrett throughout his work life, 37 years. I am telling you all of this because I want to give you a sense of the strong values with which we were raised. We grew up in a traditional old world family which took with a strong work ethic and a sense of what was important in life. We did not have a lot in material goods, but we were well loved, and each one of us knew that our parents loved us very, very much. Our mom was wonderful. She was extremely bright and created a stimulating environment at home. She was a den mother for our brothers and was active in the church and the school. She embraced life and was one of the most optimistic people I have ever known. I remember her smile and the upward tilt of her chin whenever she watched one of us at a dance recital or a PAC meeting. Daddy didn't particularly like sports or outside activities. We were his leisure, and I can remember him saying how much he liked his job because he could leave it at the end of the day. His focus was on us. He especially liked geography, and I remember evenings after dinner sitting at the table, all of us, testing one another on countries and their capitals. It sounds too good to be true, but it was true, and we were a very happy family. Then, when she was about my age, our mother was diagnosed with breast cancer and had radical surgery. She was in remission for several years, but the cancer returned, and she was sick for a long time. But even through the radiation and the chemotherapy, she managed to worry about us and take care of us. I remember her weaving a wreath of flowers for me to wear to my junior prom. At age 39, she died, leaving 4 children, ages 11 to 17, behind. I can still describe what a sad time that was for all of us. 18 years later, we still miss her loving presence in our lives. Linda was 5 years younger than me, and for a time I tried to step into my mother's role. Linda and our brother Ray, who is here today from Germany, were very close at this time. We clung to one another because after losing Mom, we knew how precious family is. Poor Linda was the youngest, and her 12th birthday was just 2 weeks after Mom's funeral. Mom, who had always made such a fuss over special days, wasn't there, and Linda's birthday was forgotten that year. When I went away to college the following year, Linda told me later how abandoned she felt. She started working as soon as she could because, like all of us, she had that strong work ethic. Linda was a fabulous babysitter, and in Salt Lake City there were lots of opportunities. The families on our block liked to have Linda watch their kids. Linda loved one family in particular. They had 7 kids, and Linda went over almost daily to help Joanne, especially with the twin baby girls. Linda had a knack with babies, and many of us can tell you how she loved to hold any baby in sight. She loved children. She was so happy when our son Matthew was born and came to visit us while he was still an infant. She was a delightful, fun-loving aunt and often sent little things to the kids, such as pencils with their names printed on. They were simple things, but evidence that she thought of them often. Both of my brothers can also tell you what a wonderful aunt she was to their children. Obviously, Linda was beautiful. We happen to have come from very handsome parents, but that is not why people were drawn to her. She had that same joy in life that our mother had, and people, both men and women, wanted to be around her because she was such fun. I never laughed more than I did when I was with Linda. Her friendships were based on the same values with which she was raised. It is dismaying to those of us who knew her well that Linda has emerged as some kind of gold-digging bimbo. She was very quick and intelligent, and anyone who knew Dan knew that he had a low tolerance for ineptitude, and she would never have continued as his legal assistant if she had been stupid. Linda was unusually cautious in forming romantic relationships. I believe that she could have become involved with several men equal to Dan in stature, but never did. When she confided her relationship with Dan to me, I knew that it was important. Another relationship would have been so much easier, but Linda truly loved Dan, despite all the problems he would face. It was a testament to her deep and abiding love that she hung in there with him through all the harassment and obsessive haranguing by Betty. As Betty's actions became more than just an irritant, as they became increasingly violent, we grew concerned for Linda. But she loved Dan, and unaccustomed as he was to a loving partner, loved her very much. I remember so many calls of frustration from Linda when Betty had left yet another obscene message or worse, and I questioned Linda's wisdom in staying with Dan. For my part, I could not have tolerated that litany of abuse. With each passing year, as we became adults, Linda and I grew closer than ever. She was my dearest friend and my greatest champion. She celebrated my successes and was a rock in times of trouble. I feel very lucky to have had such a loving sister. To help you understand her warmth, I'd like to play a tape of a message that she left on my answering machine.
The recorder doesn't have to take down the tape.
Yes, Your Honor.
Yes, Ron. Go ahead.
Hi, Robert Mary. It's your sister. I was cleaning out my closet this morning, and I came across the letter that you gave me on my wedding day. I just wanted you to know I found it. And I just read it. It makes me cry because it's so nice. I hope you had a good time in L.A., and I will talk to you next week, I'm sure. See you. Bye. Love you.
Linda left that message for me on Saturday, November 4th, 1989. Less than 24 hours later, she was dead, killed with 2 well-placed bullets, first to her chest, and then, as she lay dying, another to the base of her skull. And now, at long last, what we all knew is now a matter of public record. Betty Broderick was not justified in deliberately killing my sister and Dan. She did, in fact, murder them. And on Sunday, November 5th, 1989, while I was in Los Angeles doing some work, my husband called me and said, "Margaret, your sister is dead." He has since expressed regret over the bluntness of his news, but no words, no matter how well chosen, could have softened the impact of those words. Linda, our dear, happy Linda, was dead. This is called an impact statement, so I will try to describe the impact that Linda's murder has had on us. That first numb week as I worked with Dan's brothers, Larry and Dennis, to put together a double funeral, the initial phone calls from the media began. One by one, family members arrived in San Diego. Whereas we had gathered 6 months earlier to celebrate a wedding, we now quietly gathered to cry and mourn. I returned home to my home in Portland, Oregon, where my shocked children tried to cope with the news that their beloved Aunt Linda had been shot. For months, Matthew had nightmares of an intruder breaking into the house during the night and shooting us in our beds. Just 2 months ago, when 2020 did a program on this, we chose not to watch the show. But 2 evenings prior to the airing, they showed a commercial advertising it. Until that time, we had successfully avoided any pictures of Linda dead, but there, suddenly on the television screen, was a picture of my sister's body, and I watched the blood drain from my 11-year-old son's face as he saw it.
Don't know yet, Nancy.
Our little Elisabeth had a delayed reaction weeks later, finally letting her grief out when it was triggered by a photograph. My brother Ray and Roger, who was stationed in the Air Force in Turkey, struggled with their loss. All the more painful because they had not seen Linda for several years and had not had the money to attend their Linda and Dan's wedding. And our poor daddy. He and our stepmom of 16 years miss Linda so very much. He does not have the emotional fortitude to be here today. He told me, "Oh, Margaret, I can't be there." He simply could not be in the same room as the murderer of his youngest child. And I know what he means. Until today, I had not seen the murderer before. Daddy doesn't get his Monday night phone calls from Linda, who was in frequent contact with him. He doted on her, and she adored him. At their funeral, Mike Reedy and his musical partners sang "Make Me a Channel of Your Peace" at the funeral mass. Daddy cannot listen to that song or Danny Boy without crying. Daddy lost his wife 18 years ago, and his daughter, who was only 28. I pray often that nothing else bad will happen to our family. The impact of the media has been substantial. The murderer, who hired a public relations firm early on, and her attorney have been very aggressive in courting the media. Our families have tried to avoid the media, but have been compelled to talk to them. The defense strategy has been to paint Linda and Dan as villains, and we are put in the position of defending their right to be alive. They are the ones who were murdered. They have been put on trial. I am baffled by it. Linda and Dan were murdered. They should still be alive. But they can't speak for themselves anymore, so we must try. I only want the media to know how painful it is for us to have our tragedy turned into primetime entertainment in the Sunday night movie. We are not characters in a bestseller novel. Linda and Dan were real people, and we are real people. For my part, I miss Linda in 1,000 ways. I miss laughing on the phone with her. I miss singing to the talking heads at the top of our lungs as we go down the freeway. I miss celebrating successes such as my degree and my new dream needed. I wanted to be an aunt to her children. I wanted to spend a lot more time with her. But she's dead. And when the pain of her death is especially strong, I hold her white cotton nightgown to my cheek and rock and cry bitter tears. She was only 28 years old, and for the rest of our lives we will be without her. No sentence could ever be in proportion with what was taken from Linda and what we have lost. Thank you, Your Honor.
Thank you.
Terry Broderick would like to speak at this point.
Good morning, sir.
Hello, Your
You'd
Honor.
state your name and spell your last name,
My
please.
name is Terry Broderick, Broderick.
Yes, sir. Go ahead.
I'm speaking here on behalf of my brothers and sisters and of my mother and father who can't be here today, and on behalf of Dan and Linda. Dan was my eldest brother, the eldest of 9 children. He had 4 brothers and 4 sisters. All the boys, including Dan and my father, went to Notre Dame, and all my sisters, 2 of which went to St. Mary's, and the other 2 went to 2 other universities. But they say that a picture is worth 1,000 words, and we've had this picture in our family for the past probably 40 years. And if I could present it to the picture is basically a picture of a child on his first day of school, and that's my brother Dan, and it was his first day of school at St. Bernard's. And as you can see, the principal of the school and none is overlooking him, and he's looking up to her with, I think, a trusting look and not knowing what's ahead of him. And that picture to me is also symbolic of what you have before you today. And in as much as Dan in that picture represents the innocent people in society in general. I have some notes that I wanted to go over. As far as my parents are concerned, when they think of Dan and the loss of Dan, they do not think of a fellow that was 44 years old. They think of a child that they placed into this world and who grew up, and they tried to instill the right values in him. And as it is said, it is a long and hard and painful to create life, and it is short and easy to steal the life others have made. And I would hope that the court will show us that the lives that they had did not go in vain and did have some value. Once again, my parents grew Dan as a child into an adult person, and I believe Dan, through the course of his journey, chose to do the right things in life as opposed to the wrong things. He had options in front of him, and some would have been easier. Some of the things would have been easier to deal with Betty in her times of trouble, but he tried to do the things the right way, the things that I think all of us would hope to do in our journeys. And so my question when I look at that picture is where did he go wrong? What did he do wrong to get the rewards that he and Linda both received through Betty's actions? And I looking at the whole thing, wonder what did she do right where she would have some type of reward that would be less than the maximum penalty in front of her. The point in doing right is to make if they cannot look to the system of justice for the right answers. And once again, that picture to me is the same as people looking to the system for answers, some type of directive. If justice does not act as the counterbalance to those who do us wrong, then what is the point to all this? There's no path of destruction in Dan's wake and his actions in life, and he has no reward to show from it other than his good friends. I think that when all is said and done, I think the media has basically dragged his name through the mud in exchange for a good story, something to sell more newspapers. And if I look around and I say, what was the point of all his achievements and everything that he's reached for in life? I think the evidence that I see before me is his loved ones and his friends, and those are evidence enough of me, of the type of person Dan was, and I appreciate them. What kind of message are you going to send to those out there in a state of crisis? Those that choose to do right, those that end up with taking the evil, selfish, destructive side. I received a letter yesterday from a person that I'm not going to mention, never heard of this person before. She said, she tells me her name, and she says that I'm in a similar situation to Dan and Linda, and I would be like Linda is. I am married to a fellow who had been married once before, and basically have been subjected to everything that Dan and Linda has been subjected to except murder. And she says, and she does not see that to be something that wouldn't happen also down the road. And she actually writes this letter and asks me, what is she supposed to do? How does she handle it? Does she take the law into her own hands like some would have thought Dan should do? And in which case, Betty might have ended up in the hospital 2 or 3 times. Dan would have been in jail. And a lot of people in America would have done that. They wouldn't have chosen to do the right thing and to put their faith in the judicial system. In terms of people being divorced each year, there are thousands and thousands and thousands of people that are divorced. Probably at least 50,000 in California each year get divorced. And if an example is set up where a person is rewarded by giving some consideration and leniency in their punishment, how are these people going to look for that in terms of a solution to their own problems? On the behalf of our family, we believe that less than the maximum sentence, and I don't know exactly what that is. I believe it's life in prison without parole for each of the murders, is a victory for the convicted. To Betty Vichelia, who shows no remorse and acknowledges no wrongdoing or responsibility. To her, Dan and Linda were worthless trash who got what they deserved. And anything less than life without parole rewards her and is a token of acknowledgement of her so-called victimization, a degree of credibility and justification of her heinous crimes. Anything less than life in prison for each of the victims, Dan and Linda, implies in some way that they are less than innocent and therefore are entitled to less than most of us would expect for ourselves. If this was a state such as Texas or such as Florida, she would probably be going to the gas chamber or the electric chair. But this has been a series of compromises from my perspective. At no fault of the DA's, I believe that the first compromise was the fact that she could have been charged with first-degree murder with special circumstances, which brings with it a capital offense, and which can be death. The second compromise, I feel, was a compromise by the jury, and I applaud the jury for coming up with the conviction, but it was a compromise to get the conviction. And now the possibility of her walking away from these crimes at some point in the future, I believe, would be devastating. Please do not further compromise the standards of the justice we have grown to count on and expect, which mandates the nature of our own actions. Do not reward her with a less than maximum sentence by giving her something to look forward to and punishing our families in a sense with the constant knowledge of her temporary incarceration, and will walk away free someday. End this for all of us. It will be a great blow to the memories of Dan and Linda and all that is right and good in this world to let her go away from her crimes. Send a message to those treading similar waters and restore dignity to Dan and Linda's names and to all those that work hard to stay true and straight. Please put an end to this for all of us. The triumph of justice is our only peace.
Thank you. Thank you, Mr. Broderick.
Mr. Monahan also has a few words for the board.
All right.
About 2 years ago,
State your name, spell your last name for the record, please.
Brian Monahan, Monaghan. At the funeral of Dan and Linda, Larry Broderick at the last minute asked me to speak on his behalf. I'm doing that in a sense today, but also for people like Ray Kolkena, who's his wife Ava, who came all the way from Germany, staying in my house. For the 17 people that went to Ireland this year to dedicate a church to Dan and Linda and to put some of their ashes in the ground of Ireland. For clients of Dan's who came to me after his death, for friends like Mike Neal and Vince Barlotta, Mike Reedy, for a lot of the people that were affected. I guess I probably should explain what my basis for this is. My experience with Dan, with Betty, with Linda goes back a number of years. I met Dan when he was still at Harvard Law School. He interviewed out here in 1973 or 74. We practiced at rival law firms. We tried at least one case against each other. We became the best of friends. We met at least weekly. I served as his attorney occasionally. He served as my attorney. I was his vice president, or one of his vice presidents, when he was president of the Bar Association. I shared at his house probably the last Thanksgiving the family had together. I shared with my family and his family probably the last ski trip, Christmas ski trip that they had together. I met Linda when she... that's the background. I think there have been horrible distortions put before this court in the two trials. One of the distortions is that this was a happy marriage. It was never a happy marriage. Those of us who saw it knew it wasn't a happy marriage. Dan cried 2 weeks after the wedding on a bus in New York City, in the back of a bus, cried because he knew that he was into something that was horrible. He made a terrible and tragic mistake. Betty drove that marriage into the ground for years and years and years. Second thing that I think is intolerable is to paint her, as she's done so well, as the victim. She made choices. At the time of the divorce, Betty was not the person you see sitting in this courtroom. She was a beautiful woman. She was intelligent. She was rich. She had a home in La Jolla, $16,000 a month. She had a lot that she could have done with her life. She had a wonderful future ahead of her. She had friends like Helen Picard, Gail Forbes, who urged her to get on with her life, but she chose. She made a conscious decision not to get on with her life. She chose to spew hate on Dan. She chose to use her children as weapons. On the morning of the murder, when she stood in that bedroom, having already shot Linda, looking down at the father of her children, gurgling in his own blood, with one bullet left in her gun, she chose to step across the room and plant that last bullet in the back of Linda's head. That was her choice. Having killed him, she chose to take away the last thing that they had, their names. And for the last 2 years, she has done nothing but tear down their good names. None of us can repair that. She chose to take this, the slime story to the tabloids, to take it to the supermarkets of America. One story said, "Why did Betty wait so long to kill her husband?" That was the title on the front of the magazine. She pandered to those. And during that whole time, there was not one hint, not one suggestion of remorse. The picture of Betty Broderick at the reading of the verdict is a picture that tells as much as that picture that you have before you of Dan on the first day of school, and that is a smirk on her face. She beat the system. She got away with second-degree murder. I'll never forget that smirk. It reminds me of the statement that she made to the bailiff, that she had the jury eating out of the palm of her hand. She's a woman without a drop of remorse to this day. She remains a threat. I described her quite accurately to one of these media people. The next day I got a call threatening my life from somebody. She's threatened her daughter recently, Kim. She's a threat. She has made choices. She made the choice to go to the tabloids with this. She's got to suffer the consequences of that. She's responsible for the choices that she made. All these people out there in this country, deterrence is one of the things that the court has got to consider. All these people have read her side of the story, and they're now waiting in supermarkets all over this country to find out what sort of justice we dispense here in San Diego. What the people of San Diego feel about these acts. It's in your hands.
Thank you, Mr. Monahan. Anything further, Ms. Wells? Mr. Ehrlich.
Your Honor, sentencing in this court is in an open courtroom, and the court has considered, for the main part in this case, evidence that has been adduced in an open courtroom. That is not the history of this case. It is not the history of the case. It is not the present of this case. It's not the future of this case. I've been shocked when I have read in the district attorney's discovery and our discovery with witnesses that there was a divorce in this county that stretched over 5 years, that there was a move by Mr. Broderick and his attorneys to have all those hearings closed, which means that they know that the purpose of having it closed is so that nobody knows what's going on, one side or the other. But Mr. Broderick must have decided that my story will get out about the bad things about Elisabeth Broderick, because he talked about what went on in those courtrooms. He talked about the problems he was having, even though he asked those hearings to be closed, even though he asked that information not to get out. The reason that I bring it up is the district attorney argued a statement from Kathy Broderick, and she argued a letter from Kathy Broderick. And Kathy Broderick asked for a closed hearing, and she's been hiding behind those closed hearings. A court in San Diego will never find Kathy Broderick in contempt, will never bring forward that she asked for a closed hearing, but when she thinks it suits her, she'll bring out what information she wants. I don't want this court sentencing Elisabeth Broderick because they say that she has no compassion for Kathy Broderick because she has the children of Elisabeth Broderick. The district attorney read a letter. The district attorney did not choose to write the letter that Elisabeth Broderick got in the middle of the trial from her child that was burned at the bottom, that said he wanted to kill himself because he could not stand to live in Kathy. Tried to bring forth a letter that for 1 year after she was incarcerated and those children were whisked for Colorado, she wasn't even able to send a card to her children. Happy birthday. Merry Christmas. Not even a card.
Yeah, whose fault is that?
When she brought up Larry Broderick, I would like the court to include as a letter Larry Broderick's. I would be inclined to play the tapes and have boys testify as late in the trial as possible. She didn't care. He didn't care about the children. They looked at him as pawns in a game. Those children, Kathy Broderick, who was in there, when Kathy Broderick had those children, Elisabeth Broderick said, that's where my children want to be. And if she is a good mother to them, that's where they should stay. And then the children complained about being there. They don't want to be. They have other family members. It's against the, it's in the opposite of what the code says to look for. And members of her Kathy Broderick's home, even though she was going through a divorce. Even when those kids had over $400,000 stolen by Larry Broderick, they said, don't sue Larry Broderick for their money back because it might affect Kathy Broderick and her home. So the boys should give it up so that Kathy Broderick doesn't have a problem with that. And in the hearing, when it was recommended by the county that she be not made permanent guardian because of problems with the children, because of conflicts of interest, because billings that have been called into question in the probate court by both the attorneys that represent them, conflict of interest, that represent Larry, that represent have a relationship. Things that don't come out in the public. Those are the way they want them. None of those things are true, and those hearings remain closed. And then the court is told that this is all protection of the children. What the court is told is what they want the court to be told. If they want the hearings open, if they want to give information, they should bring that information forward. That letter was about a hearing where the boys were saying, I don't want to live with Kathy Broderick. My cousins hate us. They fight us all the time. They scream at us. We feel unwanted. If we mention our mother's name in the household, we get in trouble at all. We want to talk to our mother. We want to visit our mother. She is our mother. And we don't want the estate to spend thousands of dollars on our wishes. And so when she went to gone from being the guardian of the estate, if that's your desires, and that's what the recommendation is. Why should you have to be there at that point in time? But the court is only told one letter. The court told that Elisabeth Broderick hired a media consultant. Elisabeth Broderick never hired a media consultant. Never with her consent, did not keep the lawyer that decided to do that. But they talk about her being in the media, and that's the only thing that she wants to do, get in and ruin these people's good name. What was interesting at every hearing that we had in this case, there was a planned, orchestrated event around Dan Broderick. It's interesting, in the Dan Broderick room, there's a plaque of all the lawyers, and there's a portrait as that the boys ended up paying for that they didn't know, and the public never knows that. They don't know it at all because it's a media event. When they go forward at the time of the preliminary hearing, and they had a memorial, when they had a time at the planning of a dedication of a church, was at a time when the trial was about to start.
Her eyebrows
And I don't even have to remind the court of the number of statements about Mr. Broderick's belief of the Catholic Church and his estrangement, and not.
She's a natural blonde. Her eyebrows are blonde. You don't dye your eyebrows. You can't, because they're on top of your eyes. You get those chemicals in your eyes, you can go blind. But
as you age, when you're a natural blonde, your hair gets darker. And I know that because my husband is a natural blonde. And by the time we met, his hair had darkened to a brown color. And now he's gray. But she did now this was in the movie. I'm not sure if it really happened. But one day before court, she got in trouble because she wanted to go get her roots done. So I don't think they let you color your hair in prison. Because if you notice, all these people that go in with blonde hair, and then you see them, if a professional does it, maybe. But every time you get the box, if you're doing it yourself, they say on the box not to do your eyebrows. I've never done my eyebrows because I don't want to go blind. Or it burns when you do your hair if you accidentally get some in your eyes when you're rinsing it out. I ain't about to do that to myself. Maybe a professional. But look at her eyebrows, though. Well, you can't see them now. But they don't look like they've been lightened. They look like they're real blonde. Anyway, in the movie, she did want to go do her roots because she had to go to court. And they got mad at her. She got in trouble. But they didn't have like a beauty shop thing to go to. I forgot what rooms they were going to. Someone was going to do her roots for her. I forgot what room she wanted to go to. It wasn't like a beauty shop thing. But I swear her eyebrows don't look artificial. They look like real natural blonde eyebrows. Look at her eyebrows. I don't think that's fake. I think her hair is just like darkening like natural blondes darken. My stepdaughters, they both have blonde hair, but they're all the time putting whatever color on their hair. So when Casey was in high school, she would use highlighters. That's how white her hair is. She would use highlighters in her hair rather than like hair dye. I'd be like, girl, quit putting highlighter in your hair. So, yeah, professionally it can be done. Yeah, because you're like laid back and someone's doing it professionally and you're not going to get it in your eyes. I'm talking about doing it yourself. Because I don't want to get it in my eyes and go blind. It burns like crazy if you get it in your eyes when you're rinsing it out after you do. Did you really? Well, you guys rock. Man. I can't do that. When I was a kid, that was one of the things I wanted to do when I grew up. But I outgrew the desire to be a hairstylist. Which is good because with my shoulder... Yes, Marty, see what you started? Which is good. And my shoulders, I would not have been doing it for very long. It would not have lasted. Oh, that makes sense. Yeah, that makes a lot of sense. Okay.
Made as a marriage encounter about it. Yes, there are times when there are two sides of the story. And what's been portrayed is that the defense and that the media are reporting the other side as well as the side that wanted to be believed by half the people. I think that the court should consider the side. I think the court should look at the history of this case. And I agree with everybody who has come forward. I believe that this is a tragic case. I believe that there has not been two victims. There has not been 6 victims, including the Broderick's children. There's been the Biseglia family. There's been Elisabeth Broderick. They are all victims.
I keep begging Travis to let me do his blonde again, and he won't let me. But he doesn't have as much hair as he used to either.
And they are victims of the things that happened in this case from the beginning to the end. Whether you want to believe how they came about, who caused them, but what you had in Elisabeth Broderick is a woman whose life was decimated, and it was decimated. And she suffered at that time, and she committed acts that she should be punished for. It has never been our position that she has done nothing wrong at all. And I don't think it's the court's position to look at the sentencing that the court is looking to melt out in this case and to say that there won't be any punishment in this case. The punishment in this case will be great. If the court is to pick a concurrent sentence, under the present parole guidelines, the earliest that she would ever get out, with just one, not even, and that's if the court just stayed one, would be 20 years of actual service. And that means that she would get out at the age of 65, would be the very earliest that she would get out. I am asking the court to consider, and the reason that I put in the guidelines asking for concurrent, the court consider that life. At some point after serving at least 20 years, that she would have some ability to die outside of prison. Probably the hardest thing that this court is going to do is look at this and saying, we are not sentencing Elisabeth Broderick because she killed somebody who was in the system. It's disturbing to see that in the newspapers, there's comments from the legal community that don't even suggest it as the court. They're confident that Tom will do the right thing. They're confident as to what the verdict would be. And that's without hearing any, hoping that would happen without hearing any in this case, having the court consider anything in aggravation, in mitigation, and whether the sentence should be concurrent, whether the sentence should be consecutive. It's going to be very difficult. The court has nothing to gain, at least among the legal community, to look and view this case any different, to say whether the court should give it a concurrent sentence. And I just think it's impossible for the court to look in this case and say, what would have been the outcome of this case if we would have had someone who was not in the legal system? If we had someone who was a plumber or a newspaper writer or a banker, because you just cannot remove that. But I would ask the court, when you look at the incident itself, when you look at what she was going through, I can't see how the court can say that this was not something that was part of just very large emotions. Everyone has asked the court just to ignore the jury verdicts. I think that if the court is to look at the jury verdicts, if the court is to say that we are a system that has a jury system and we follow the decisions that were made by the jury in this case, there's only 2 theories, and I brought it out, that the jury had to look at provocation. Maybe they didn't agree it was sufficient enough to say that it was a manslaughter. But the only way they could have reached a verdict of second-degree murder was either under a theory of implied malice or under a theory that there was provocation that brought these acts about. They took place in a very short period of time. The court, by giving concurrent sentence, is not sending any message out that people will not be punished. Elisabeth Broderick will probably spend virtually all of her life in state prison. The only thing that we are asking this court to do is to consider of whether she should have some opportunity at some point in time to contribute something. No argument that she shouldn't pay. She will pay for a very, 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 very long period of time. I'm asking the court to consider the fact when you see all of the Elisabeth Broderick's friends who have come forward, people in the neighborhood that knew her, her neighbors, her friends, the mothers, the woman who saw her on her day-to-day life describe somebody completely different than what happened to her in 1983, 1984, 1985, and the period that followed. I think the court, when it looks at the deterioration, the absolute physical manifestations of what she was going through and the things that brought her here today, can see that she is a victim, as well as her family, as well as Dan Broderick, as well as Linda Broderick, as well as the 4 children, and all 4 children. Even though Kathy Broderick, they had children, the only one she mentions in her letter, she leaves Lee out. And that's because Lee was at least somewhat understanding of her mother, understood what she was going through, understood that the pain she was feeling. And what I'm asking the court to do is to also consider that, and consider the fact that she has been a contributing member of society. She has done very well for society in the past, and I believe after that period of time in incarceration, after going before a review by a parole board that will be looking at all of the issues presented by these people, all I'm asking for the court is that she have some opportunity, given her age, her position, to at least be able to come out and die outside of state prison. And I would ask the court to look at the evidence, and I would ask the court to make the determination on the jury verdict, on the evidence that was presented and what the court saw. And I would ask the court to resist, and I can't say it any other way, to resist the temptation of looking to say, am I a hero in the legal community if I give her consecutive time? And am I looked upon, down upon in the legal community if I give her concurrent time? And I would ask you to base it on the facts of the case and on the totality of the circumstance that you have before you.
Thank you, Mr. Early. Mr. Probation Officer, anything further from probation?
Nothing further from probation.
You're Mr. Gone. G-A-U-G-H-A-N?
E-N.
E-N. Just for the record. All right.
Thank you.
Submitted?
Yes, Your Honor.
Submitted, Mr. Early?
Yes, sir.
Well, let me start by saying that although there's been heated advocacy on both sides, I want to compliment all counsel for what I think was a very vigorous and competent job of presenting their respective positions. Others may second guess you, but having sat through 2 trials and lots of motions in this matter, I think you both did excellent jobs representing your respective parties. As you have both touched upon,
Except for that fight during rebuttal.
this case has been a tragedy from start to finish. It's been a tragedy for the friends and relatives of Daniel Broderick. It's been a tragedy for the friends and relatives of Linda Kolkena Broderick. It's been a tragedy for the friends and relatives of Elisabeth Broderick. But probably most significantly, it's been a tragedy on the 4 Broderick children who are basically orphaned. There is nothing I can do that can change any of that. I would also like to mention, for the benefit of those in you in the audience, that there was one common thread that ran through all the letters I received, no matter who sent them to me, no matter whose side they were, say, advocating one way or the other. That common thread was that no one thinks that this should go unpunished. Everybody believes that her conduct deserves punishment. There was one other common thread that I would like to comment on, and that is the amount of strong emotions that were evidenced in the letters by representatives for both sides. Those emotions are certainly understandable to me, but I think, and I would like to suggest to all of you, that now is the time to set aside those emotions and start a healing process. These events have gone on long enough. They've been going on for over 2 years in my courtroom. It's time to set them aside and to start some kind of a healing process. And one final comment before we get to the actual sentencing. This is something that the lawyers are certainly aware of, but maybe you aren't, you being the members of the public. I never met Dan Broderick. I never met Linda Broderick. I never met Elisabeth Broderick. I state that to you so that you can understand that I have no personal interest in this case one way or the other, and the fact that both lawyers were upset with my rulings during the course of the trial may be the best evidence that I did my best to take no sides in this trial. I tried to give them both a complete, fair, and open trial. And somebody later on will decide whether or not I was successful in that. But I want you to know that I had no personal interest in this case. No one from the legal community has pressured me to do anything in this case other than what I think is right. I've had no contact, direct or indirect, by anybody in the legal community regarding what I should do today. My sentencing decision in this case is based solely on the evidence that I heard during the course of the trial and solely upon the laws of the state of California. In this matter, probation will be denied for the following reason. Pursuant to Penal Code Section 1203.06, the defendant is statutorily ineligible for a grant of probation in that she has been found guilty of personally using a firearm during the commission of the crime of murder. For the crime of murder in the second degree as charged in count 1, as found in count 1 by the jury, the term for that is 15 years to life in the Department of Corrections. For their finding that she personally used a firearm pursuant to 12022.5 of the Penal Code, the term is 2 years consecutive by law to the term for the underlying offense. So for count 1, she's sentenced to the Department of Corrections for a term of 17 years to life. Since murder is a crime that carries an indeterminate term, as both counsel have mentioned, it is not necessary for me to state sentencing rules for determining whether or not I should impose a consecutive or a concurrent sentence. However, to avoid any and remove any speculation as to my reasons, I intend to state reasons for imposing a consecutive sentence. First, these were separate acts of violence. The physical evidence, which is uncontradicted, shows that she intentionally and deliberately aimed at both people. Physical evidence would show that at least one of the shots, regardless of what order they were fired in, was fired into the mattress through Linda's body. The physical evidence shows that at some point she fired shots at almost a 90-degree angle towards the other side of the bed, some of those bullets going through the wall and ending in the hallway. The physical evidence uncontradicted that she intentionally aimed and shot at both people. Secondly, the evidence is also abundantly clear that at the time she left the bedroom, Linda Kolkena Broderick was dead and Dan Broderick was not. Therefore, it's not just the pulling of the phone from the wall, but in my opinion, it's the carrying the telephone into the hallway and discarding it there that evidences a high degree of callousness on her part and further justifies a consecutive sentence. And last but not least, the jury found that she intentionally killed two people. Therefore, the crime of second-degree murder in count 2, I select the term of 15 years to life, consecutive to that imposed in count 1. For the enhancement of pursuant to 12022.5 of the Penal Code, the 2 years for that is stayed pursuant to the California Supreme Court decision in Re Calbrith. It's entitled to credits in this case for time served of 824 days actually served, 412 days good conduct credits for a total of 1,236 days credits. Further order, she pay a restitution fine pursuant to Government Code Section 13967 in the amount of $500. That fine to be paid forthwith or is provided for in Section 2085.5 of the Penal Code. Statutory law, Mrs. Broderick, allows you to reduce the sentence I've imposed upon you by up to 1/3 by your earning good conduct credits. The amount of credits to which you will be entitled will be determined by the Department of Corrections. You have appellate rights in this matter. You have the right to appeal from this judgment. If you wish to appeal, you must file a written notice of appeal with the clerk of this court within 60 days from today's date. If you do appeal and are unable to hire a lawyer, the appellate court will appoint a lawyer to represent you on appeal free of charge. You will also have a right to a free transcript and record of the necessary parts of these proceedings that were held in this court. The written notice of appeal must be timely filed. Do you have any questions about your rights to appeal, ma'am?
No.
You understand your appellate rights? All right. That's the order. Thank you. We're in recess. Oh, excuse me.
No, I have one other additional request. Even though the California Institute for Women at Frontier is probably the most high-level institution, it does offer some psychological counseling, and the court cannot order her placement, but I would request that the court at least recommend that they consider her placement at the California Institute for Women at Frontier.
All right. I'll the prison packet show the court recommends she be housed at Fonterra. We're in recess. Thank you.
Okay. Look at that, guys. We did it. We did it. Why do I look like that? I'm not looking down. I'm looking straight at the camera. What the fudge? Why is it frozen? I'm going to turn the camera back off. Because I don't like that. I don't like that picture frozen. Because I'm not looking like that right now. Okay. Yeah. Okay, now, if you guys want to start Brooks today? I think we're going to start Brooks. I think, let me see, the first thing is the pretrial hearing, and the first part, dang, 5-hour pretrial hearing. Dang. So the first half is 3 hours. I don't know if we're going to do a whole 3-hour pretrial hearing. And the second half is 3 hours. Yeah, we're not doing the whole pretrial hearing. We'll do part of it. I like your hair in that picture, Nichelle. It's very pretty. Okay, let me see if my... No, it's still frozen. Okay, I'm going to end this stream, and then it's going to redirect you. It should redirect you to the Brooks stream that's going to start in about... I've got it set for 2, and I'm going to take a break, grab me something to eat, go to the bathroom, and then I'll be back, and we will start Brooks. And I don't know how late we'll go with Brooks. I guess it depends on... It just depends, I guess, on how long we want to watch it. Okay, guys. I'll see you in a few minutes.